Okay, ladies and gentlemen, we'll get this started. Thank you very much. I'm going to call this meeting to order. It is 1:33. For those of you who came here for 1 o'clock, I apologize for the delay. And confirm that all members are present, 9 here in the room and 1 via Zoom on the 2 screens. I also will confirm that we have the CAO, we have the clerk, and we have several other members of our senior management team either present here in the room or joining us from their offices via Zoom as well. I want to start by acknowledging that we are on lands traditionally occupied by Indigenous peoples. Indigenous peoples have cared for this territory for the benefit of future generations, and their stewardship throughout the ages is recognized. Before we start, I'd like to let everybody know or remind everybody, if you've already been here, that today's meeting is being live streamed. It's also being recorded on the Township of Muskoka Lakes website and on our YouTube channel. Also, by participating in the open public meeting today, you are consenting to your image, your voice, and your comments being recorded and posted online. I would also point out that public input on our agenda was invited. to all members of the public at TML public comment at muskokalakes.ca. And to my knowledge, no comments were received. No comments were received. I will also point out that there was a supplementary agenda issued, and will be part of today's proceedings. It falls under the heading of public comment, and it gives the opportunity for Susan Eplett and Ken Pearce to speak regarding item 9A4 on the procedural bylaw. With that having been said, I would like to ask all councillors whether or not they have a pecuniary interest which needs to be disclosed based on what they know of today's agenda. Seeing none from anyone else, I will volunteer that I have one. It is item 7B. The Windermere Lions Club are raising an issue concerning fees. And because I'm on the executive board of the Port Carling Lions Club and the issues are similar, I will recuse. Deputy Mayor Mazan will take the chair and I will step out of the meeting for the duration of that discussion. Okay, make sure I didn't miss anything. I don't think I missed anything. So we're going to jump right into the agenda. We have many delegations. We are going to hold everybody to the strictly to the timeline that's available to them. There will be a reminder, 30 seconds? 30 seconds. Do I have to watch for that? Oh, you will do that. Thank you. 30 seconds before the end of the time period that's available to you. And the first delegation is from Steve Fahner, who is agent for Valenti on file B/54/22/ML. Is Mr. Fahner in the house? Yeah. He is. Thank you. There he is. Welcome. File B/54/20/ML. Mr. Fahner in the house. Yes. Thank you.
Yes, thank you very much, Mayor Kelley and members of council. I'm just here on a couple of matters and I don't have too many comments to really say. Oh. My apologies.
Are you still listening to us on the delay?
My apologies. I had my phone on, so that was part of the issue there. So thank you very much, Mayor Kelley and members of council. First matter I'm dealing with is the Valenti matter on Lake Joseph. This was for the creation of an additional lot. And I'm really just here because there was an objection. I don't believe the objector is here. Staff did support the application. The owner of Bottle Island objected, but I would point out it is a picnic island. There's no dwelling on that island. The navigation channel goes on both sides of Bottle Island. In fact, the main channel is on the south side of Bottle Island and does not go directly in front of my client's property. And I would say too that that has no impact on the severed lot that's being created here. And the dock that's been placed on the retained lot, a fairly new dock, does comply with the zoning bylaw and a building permit was obtained for that. So anyways, I'm hoping that council will see their way through to approving the recommendation, and I'm here to answer any questions. Thank you.
Thank you, Mr. Fahner. Does anyone have questions on the Valenti file for Mr. Fahner while he's on that matter? Seeing none, move on to the next. Thank you. There are no questions in the room. Mr. Fahner, if you want to move on to the next one, the Baker file.
Yes, I just have to shuffle a couple of papers here. Thank you. Again, it's Steve Fahner, and I'm sorry I didn't identify myself initially, but Steve Fahner of Northern Vision Planning Limited, 109 Meadow Heights Drive, Bracebridge, Ontario, P1L 1A4. On this case, I'm representing Brian Baker and siblings. And I'd like to thank Sam Sawyer for his detailed report. Certainly it's a very complex matters of lot additions. And the only issue was the floodplain condition. And Mr. Soy and I have worked together to come to a mutual agreement on the latest wording of that particular condition. This is something relatively new. Obviously, the property is within the floodplain, so there needs to be something said. But we have wording now that's more reflective of what's in the official plan. And that is basically it touches on three things, and that's regulating construction within the floodplain, safe access, and as well, lastly, allowing for minor additions provided there's no impact on flood flows for Lake Muskoka. So that is actually, it reflects what's in the updated official plan, and we've revised the wording to that. And the approval of this will be of great benefit, certainly to the Baker family. Now, I understand that Melissa Cope may also be on, and Brian Baker may also be on, and I'm not sure if they have any comments, but that's really what I have to say. And again, I'd like to thank staff for their assistance.
I think Melissa Cope is in the room. Did you have anything you wanted to speak on this issue? I'm not prompting you. I'm just curious.
Can't hear me there. So I was just asked by Mr. Baker to attend in case there was questions regarding the applications, because it's a little bit complex, all the stages of that one. So I'm just here if there's questions, but I don't actually have anything else to add from what Steve had.
Thank you. And Mr. Fahner mentioned Mr. Baker. Is he present? Does he wish to make a comment as well, or should we just look for questions from council? I'm not seeing or hearing anything. I'm going to go to council. Does anyone have any questions for anybody on this Baker file while they're with us here? I'm not seeing any popping up, including on the screen. So thank you all. This will be coming up again a little bit later on, but thank you for your input at the present time. And we will move on. Thanks, Mr. Fahner.
Thank you. Have a great day.
Thank you too. Okay, the next one, there are two delegations on the Donaldson Sifft file. First one is Chris Morgan. When he's done, and assuming there's no questions, we will call on Ken Pearce to come up and do his delegation as well. Mr. Morgan. Go ahead.
Thank you, Mr. Mayor and councillors. I present new information in this presentation. The Ontario Fire Code and the Technical Standards and Safety Act of Ontario both deal with the storage and handling of gasoline. However, where the TSSA and the Fire Code address the same area, the TSSA overrides the Fire Code. But if the TSSA is silent in an area and the Fire Code covers it, the Fire Code governs. The Fire Code rules in my written materials and which I address today are not addressed in the TSSA, and so the Fire Code is the relevant rule book. Next slide, please. A tanker truck that unloads gasoline to a storage tank must be at least 6 meters from a source of ignition. An automobile engine and its hot exhaust system is a source of ignition. There has to be 7.5 meters between the fill stem of the tanker truck and the top of the storage tank during that refueling. Next slide, please. This is a map of the Mortimer's Marina provided by the applicants. The above ground storage tank is in red. The proposed parking spots nearby are in blue, and the possible locations of the fuel tanker truck are in yellow. The yellow placement on the left is unlikely because the tanker truck would be pointed uphill and on a side slope. As you can see, with this parking in the way, the required 6 meter and 7.5 meter clearances are not achieved. The 3 parking spots to the right of the storage tank would not be allowed. Those to the left are suspect because they are on a very steep side slope. The angled parking spaces would also not be compliant with the clearances under the Fire Code. The disaster scenario is if, during fueling, the storage tank in red catches fire, the 3 cars next to it in blue catch fire because they are a source of fuel. The tanker truck in yellow then catches fire, and the cars in the angled spaces in blue catch fire since they too are a source of fuel. The fire department would not have access to put all those fires out, or any other consequent fire at the fuel dispensing pumps or the retail operations at the top left of the map. Next slide, please. What are the implications of this? Under Township Zoning Bylaw 3.28, at a marina, 1 parking space is required for each boat slip available and 1 parking space for each 215 square feet of retail space. At Mortimer's Marina, given the existing slips, the proposed slips and retail, they need 23 parking spaces. They were marked on the map that I just showed you. If we eliminate the 14 parking spaces around the tank for fire code reasons, that leaves 4 are required for the retail operations, half of which were constructed in the last 5 years, and 6 are required for the presently existing docks. So there would be no parking spaces to support the proposed docks redevelopment, and that would leave 0 slips available for the applicants, since the lease specifically places their slips in that redevelopment. Now, it does not matter that the lease is enforceable, which I agree it is. If the parking spaces are not permitted under the safety rules, the marina cannot deliver them and the contract fails. The tenant's only right under the enforceable contract is to sue for damages. Now, you might say, well, Mr. Morgan, we cannot consider your arguments today since they anticipate the outcome of an application yet to be filed and yet to be, I suggest to you that if you adopt that posture, then you must equally conclude that you cannot approve the application to sever today because the application is based on those parking spaces being there, which also depends on the outcome of that redevelopment application. By the way, the redevelopment application is coming soon if it is not already in-house. Next slide, please. Last year, this council passed the fire route bylaw that allows the fire chief to designate a fire route which would prohibit parking for fire code and safety issues. So he should be a key player in all this. Last slide, please. Given that the parking spaces would not appear to be permitted under the fire code and that access to the proposed parking spots depends upon a future fire safety determination to be decided by the planning committee, council, and the fire chief, I suggest to you that you cannot, at this time, be satisfied that the applicants have secured access to adequate long-term parking and docking under official plan 5.24.d. Last very brief point. Go back to the map, please. Now, there is some confusion here. The parking at Mortimer's Marina is laid out on this map. If you look at the top right-hand corner of the map, you will see that it says existing parking and proposed docking. Well, if this is indeed parking as it exists today, then the proponents as the proponents assert, then the fire chief today has the ability to review and determine. Let him do his job. It shouldn't take that long. Folks, the overarching issue here is one of public safety. Moms, dads, kids. Let us not give the impression to the people of this township that we are unconcerned about their safety. Please, please defer this application until these issues can be properly sorted out.
Thank you, Mr. Morgan. Mr. Pearce?
Yes, thank you.
Do you have a self-timer? Because it worked for Mr. Morgan.
No, he's much better than I. Ken Pearce on behalf of Muskoka Lakes Association, 65 Joseph Street, Port Carling, Ontario, POB 1JO. First of all, my apologies. I'll be speaking to this when we talk the procedural bylaw a little bit later. I thought I had 5 minutes at the last session on June 15 before planning committee, when in fact I only had 2. So I really only got through about half of my presentation. So in addition, as was mentioned, there is some new information that's come forward. Concerns about the adequacy of the parking and also the safety concerns at Mortimer's Point Marina, as just noted by Chris Morgan on behalf of the Friends of North Bay. I will not repeat any of my comments from June 15. I acknowledge that your time is valuable and I won't do that. As it was mentioned, council must be satisfied that there is suitable long-term access to adequate mainland docking and parking. That's not only in your current official plan. We worked very hard to get that into the new official plan as adopted. And I would refer you to section E 4.4.4D. Just some information that you're probably aware of. When Walker's Point Marina put in a building on part of their parking lot, chaos ensued. And people started parking on the township roads. And the township worked very hard to resolve this and ultimately did. Beaumaris is another example, and the concern here is that we would really not want to see this be an issue again. We would urge council to exercise caution There does not appear to be adequate parking available, even if the lots are reconfigured, which it seems they may not be able to due to space and safety constraints. It would be extremely unfortunate to again experience parking on township roads, because unfortunately that's what's likely going to happen. Speaking to Mortimer's Point Landing, Chris was talking about the marina part. The landing is equally as extremely congested with no additional parking available that I can see. Briefly on fire safety, it's not unusual for Public Works to get in to comment on applications and the fire department to comment, especially regarding access to the site for emergency vehicles. And as we've seen where there are tall buildings to require fire suppression systems or fire egress stairs, you may recall the Muskoka Trust application not too long ago, a 4-story fire tower attached to a 5-story building. And that was just the subject of an OLT appeal and ultimate settlement. So you probably heard a little bit about that. As I intended to say on June 15, in light of the concerns raised regarding the adequacy of the mainland parking, Council may wish to consider a parking study. Thank you very much, and hopefully I didn't take more than a couple of minutes.
No, you were good. Thank you very much. Before you go away, I was remiss in not inviting questions for Mr. Morgan while he was at the mic as well. So let's find out whether anybody has any questions for either Mr. Morgan or Mr. Pearce. Councilor Nishikawa.
Thank you. Through you, I actually just want to clarify that Mr. Morgan was speaking on behalf of the MLA. And okay, that's what I just wanted to have a better understanding. Thank you.
Yes, I believe he represents 40 or 50 cottagers, and it's the Friends of North Bay, although it's not really North Bay, Ontario, but yes, that's what the group is called.
Okay, thank you very much. We got that clarified. Anyone else with any other questions? Councillor Kent.
Thank you. And I'm just not sure this is the right time. Can we hear from the fire chief? His thoughts on this, or is that not appropriate now?
He already is.
Not based on these new comments.
He's present as part of the senior management team and presumably is available for questions. And so I would think that if you have a question for Chief Morrell, you can ask him.
I wanted to hear what Chief Morrell felt about the comments that Mr. Morgan made, which I thought sounded all very reasonable.
So typically it's not common for us to make a comment about a proposed draft plan. But the plan that is presented on the slide that was shown earlier, yes, it looks like there is some safety concerns and as it relates to where the parking is related to the tank. But a typical site application would allow for the applicant or the developer to have that back and forth conversation between us and the planner. So there would be an opportunity to have some conversation with the people that are proposing the parking.
Go ahead, Councillor Kent.
If there was a parking study done as requested, would that require you to get involved?
Perhaps. Typically, we do not get involved until we actually have a complaint that is verified by us visiting the property. And then if there are vehicles parked in that spot, then we would apply our authority.
I'm going to, the CAO Hammond has asked for an opportunity to speak to that.
Thanks, Your Worship. So Mr. Pink may be in a better position to speak to this than I, but I think in order for there to be some kind of parking study, there need to be a planning application on that particular property, and that's not the case here. So I don't know what what authority the municipality would have to ask for such a study, but perhaps Mr. Pink can speak to that. Thank you.
Mr. Pink.
Good afternoon, Council. Thank you. I would concur with the CEO's comments. I think Council should be reminded that what is before Council is an application to subdivide an island, and it's said island that's before Council and said applications, not an application for a redevelopment of the marina property. We'd have no ability or authority or any, again, application on said marina property in front of us at this time. Staff's happy to respond to the any questions of Council from the earlier delegates or respond to some of the points made. However, I believe agents for the applicant are also in attendance and are listed to speak, and they may clarify some of the comments made as well. But I would agree with the CEO's comments.
Councilor Zavitz.
Thank you, and through you. So I'm a little conflicted because we're looking here at this today, and it's relatively new in terms of if essentially the enforcement of mainland parking for island property development, and yet we have to make a decision based on the assumption that they brought clean paper to this agreement at the marina, so that we should be checking that box off that there's 6 boat spots, 12 car spots, no problem. This to me is quite cloudy now, and causes me, I was going to ask the same type of question, only I would ask it through to the CAO. Who on his senior leadership team would he want to answer that question? Answer is, it's premature. I don't know when it isn't premature. I don't want to make a decision on this based on what we have in front of us, because I think there's a large question mark here. I mean, am I not right? We as a township must insist, our bylaw says, you need 6 boat spots and 12. And I don't see that that's in question at the minimum.
Mr. Hammond.
Your worship, I think Mr. Pink is best positioned to speak to the requirements of the township's official plan and the relevant policy in this case.
David, you're on, please.
Thank you, your worship, through you. I think where some of the confusion may lie is, again, similar to my previous comments, there is no application to expand the marina in front of council at this time, or I believe into the municipality at this time. Some of the comments made imply that current zoning standards need to be applied to the marina property as a result of the severance. Those are separate zoning issues. Should the marina expand their parking? Should the marina expand their retail or any other buildings on the property? The marina will have to demonstrate that it provides parking in accordance with the zoning bylaw at this time. There's nothing in the official plan or in the zoning bylaw that requires additional parking to be provided at a marina property as a result of an island application for consent. So again, not to get into the minutiae or the details of some of the presentations, you'll note that it implies retail component requires parking, and therefore they're deficient in parking. There's many properties in the township that are historically legal non-compliant, and there's nothing in a zoning bylaw or the official plan that says 4 of those spaces are slated, or 5 to retail operations only. Those are private business decisions and business matters. There's nothing, again, in the zoning bylaw that would stipulate 6 new spaces need to be provided at the marina property for the proposal. There is a lease agreement. That entity has agreed to provide parking spaces and docking spaces for the proposal. Spaces do exist at the marina property. And that's what's, again, the island and those applications for consent and concurrent zoning or whatever for council. I think, again, Ms. Cope is here, and I believe can speak to more detail as to the marina operations and maybe will provide some additional clarity.
A couple of things. Just thank you very much, Mr. Pink. Mr. Morgan, I can see you're trying to get attention. Unfortunately, this isn't a public meeting. We can't take your feedback. Councilor Nishikawa, you had your hand up.
Thank you. And through you, David actually answered a lot of what I was going to be asking him is what we have today in front of us with this particular question about severing this island and their requirement of bringing forward an agreement for docking, that they fulfilled that. That was my question to David, was did they fulfill what our requirements are under this application? And I think I heard him say that, but I also want to confirm that we are not taking this discussion any further past what the question that is being asked today. So while we can discuss all sorts of marina issues, I just am suggesting, or could I ask you that we don't do that today at this time? Because it's not the right timing, in my opinion.
And thank you, Councilor Nishikawa. I would agree with you. We need to stay focused. Really, the issue here is to ask questions of the last two speakers. The clerk has pointed out that there are 3 other delegates with 2-minute slots who are present and who wish to speak. And I think, frankly, it might be useful to have them come up next rather than in the order presented on the agenda. But before that happens, I have a question, but I'm going to hold off until everyone else has asked their questions. Councillor Kent, did you have your hand up? That's fine. You can ask questions.
Just to clarify, and I may be misunderstanding what Councilor Nishikawa said. The application is now to sever the property, the island. They will have to come back with a building plan and concept when they're ready to build the properties. Are you saying that at that point in time, this is what David Pink, I thought, said, at that point in time, that would be the appropriate time to do a parking study? I thought that's what he said. The application didn't apply to the parking study.
Mr. Pink, you're back on. Could you answer that, please?
Thank you. And just to clarify, sorry if that was the message I came across. That's not the case. Again, there's no application for a marina proposal in front, or marina redevelopment or zoning application in front of council on the marina property. What is before council is an official plan amendment, a zoning application, and a consent application on the island property. The official plan requires that adequate long-term parking and docking facilities are secured to the satisfaction of the township when reviewing said application. A marina property has entered into a lease that they will provide parking and docking facilities to those newly proposed properties, and staff is satisfied that those policies are met.
Thank you. Councilor Bozeman.
The bylaw requiring proof of parking for island properties ends with a clause that says to the satisfaction of council. Mr. Morgan's delegation potentially cast some doubt about the marina's ability to provide them. And so my question is to Director Pink is, am I interpreting the bylaw correctly? And if others agree that there is enough doubt created through by what Mr. Monroe has to say, what would our next steps be to eliminate that doubt?
Mr. Pink.
Again, through your worship, I'm not sure what it would take to eliminate any doubt in councillor's mind, although I would suggest, again, there's 3 additional speakers that may provide some additional clarity on this topic. However, it is staff's opinion that the policies have been met. They have demonstrated that they have secured parking and docking to satisfy or to access the newly proposed lots. I think, again, council needs to be cognizant that plans can change in the future. The marina may come forward with a future expansion that will be reviewed at that time, but the current property and what's proposed does have parking, does have docking. The zoning bylaw does not dictate which go to retail and which go to the slips. Keep in mind also, the zoning bylaw does allow a portion of one's parking at a marina property to be accommodated by said water access or slips. So that wasn't factored into the calculation shown earlier. So, but again, I don't really find it's necessary to get into that minutia. What's before council is the applications for consent in the island. We don't have a parking proposal or an expansion proposal at the marina in front of us.
Mr. Bosenworth, to follow up.
Thank you, Mr. Pink, but you didn't answer my question. I'm not talking about a potential application being brought forward by the marina. I'm trying to get your opinion about whether enough doubt has been 2 things. Does our bylaw, would it allow us to it has to be to our satisfaction. And if we've had some doubt cast upon the ability of the marina to deliver the parking, what would we do to eliminate that doubt? And an answer might be we send the fire chief down to ensure that all fire requirements and fire and safety requirements are being met. And if that eliminated our doubt on the ability to provide parking, then that'd be fine. What was implied was that if there was a violation and those parking spots had to be removed because they're too close to the fuel tank, then maybe there's not enough parking space for the marina to deliver what they've promised.
Mr. Pink, do you want to respond to that?
Certainly, if council wishes to direct the fire chief to do an investigation, that's separate. If you wish to do so, it's your prerogative. However, perhaps to put it more simply or in other terms, if you were to look at the schedule shown in the previous delegation, there are in excess of the number of required parking spaces that are not identified in blue. And in essence, I think that's satisfactory, that demonstrating that sufficient parking is available for the marina to meet their obligations under the lease. I think with respect, the delegation is implying as if because current zoning requirements would require a certain amount of spaces for retail, that those spaces need to be therefore utilized for retail. There's nothing in the zoning bylaw or the official plan that dictates that. This property is likely legal non-conforming or legal non-compliant, deficient in parking. However, there are sufficient spaces, again, outside those areas highlighted in blue, that can provide the access or to fulfill their obligations under the lease agreement entered into. Should the marina expand in the future, they will have to demonstrate that they comply with parking requirements for said expansion.
Okay, thank you very much, Mr. Pink. I have a question, and as I said, I wanted to let this play out. I'm going to ask it because it's specifically, make sure I'm right asking. Yeah, it's Mr. Pearce's written delegation. There's a specific reference in the second paragraph to parking and docking available at Mortimer's Point Marina and or Mortimer's Point Landing. Now, my recollection from reviewing the appendix to maybe last month's submission was that both of those parties are on the lease. You mentioned earlier, and I guess I have a two-part question. You mentioned earlier that there was a binding obligation. Does that include both of those facilities, or just the marina, or just the landing? In terms of being obligated on this lease to provide parking. I'll ask the second question. You can answer them both together. But the second issue is in Mr. Morgan's chart or map, we were only looking at the one plot. There is an additional plot of land, I believe. I'm asking this. I believe there's an additional plot of land that is also on the lease and that provides, by my count, 38 or 37 additional parking spaces that haven't factored into the calculation for proximity to a fire hazard or fire risk. And so what I'm trying to find out is, by including both of these references in Mr. Pearce in your delegation, are you suggesting that both of those plots of land and all of those parking spaces really need to be used in calculating availability?
The mic's not turned on.
There, is that better? Okay, sorry. Yes, my understanding is that the lease is with two different parties. They're both part of the Mortimer's family. One is the marina portion and one is the landing portion, Mortimer's Point Landing. They are separate. Mr. Morgan's presentation dealt with, his slide dealt with the marina portion. My brief comment was to do with the landing. I think there is around 30 spots at the landing, but my comment was that I think if you looked at a picture from a month ago during a weekend, there was nowhere to park at the landing either. And I guess the point is that some of these are prospective spots that to be built near the fuel tank and the angled parking next to it on the marina portion of it. And those may not be appropriate due to safety concerns. But I guess my comment was more along the lines of Walker's Point Marina. You put a building up on the parking lot and you've got a problem on your hands because the people that were parking there before have nowhere to park. And if you say, okay, I'm going to lease you 6 parking spots at the marina portion, and I think it was meant that 6 spots would also be at the landing portion, you're going to turf people out that are already there. I mean, you've got your binding lease. You go to renew next summer or whenever this gets built, it's conditional. Those people will show up and say, I'd like to rent my usual spot, and they'll be told no. And then you'll be back parking on Mortimer's Point Road. And that was my comment, that we've seen this happen with Walker's Point and Beaumaris. And, you know, the comment is adequate parking today. And that was the point I was trying to make. Thank you.
Thank you. Anyone have any follow-up on that? If not, I'm going to invite, who's next? Terry Ledger, if you could give us your delegation, please. And it's 2 minutes, correct? 2 minutes, please. We won't count the walk time.
I'll put my clock on. Do you require my address?
Yes, please.
Terry Ledger, 167 Medora Street, Port Carling, P0B1J0. I like to think I'm here on behalf of the silent majority, but it's just a topic I'd like to speak to. So I'll start my time. So I'm not against development. It's my business. I'm sure most of you know me. I've worked in the area in building and planning for over 20 years. And I think anybody who spent time here has watched this progress, and this is a big issue. And I understand the role of government and its job to make sure that development is sustainable and responsible. And I don't think this is either of those things. The problem, of course, is the parking, not the development itself, and waterfront landings. And the current official plan actually doesn't allow, it's very clear, it says less than 5 lots are proposed. That's not the case here. So it doesn't meet that. The adopted official plan speaks to long-term parking and waterfront access. So what I didn't find was what defines long-term. So we're presented here with a lease that's 5 years. I don't consider that long-term. Up to 20 years. That's only one generation. So are you going to defer the problem to the next generation to deal with? Or are we going to do something about it? And I think that this council has shown some appetite for making tough decisions, and this is one. Councillor Edwards can back me up. Pretty much every committee of adjustment meeting has a consent application for water access severance. It's been
20 seconds.
Thank you. Wow, that was fast. Okay, so the marinas are at capacity. We all know that. You can put whatever you want on paper. We continue to create these new water access laws, and there's no infrastructure. Our job is to make sure that that happens. So the asks were just that you withhold this third reading until private deeded landings are provided, and to direct staff to not support anything further for the same reason, and no further waterfront severance. And that we really look at this for private, public, and commercial during our transportation master plan.
Thank you very much. Time is up. Thank you.
Thank you.
Sorry, anybody have any questions? Yes, and Councillor Zavitz.
Thank you. Through, I guess, to Terry, if I might. Are you representing yourself here, or are you representing a group?
No, I'm just here. I actually live in the area, so I know the area very, very well. So
Thank you.
That's right.
I just find that, if I might, I just find that significant that someone from the public comes forward with this kind of experience and shares that with us. So thank you for that.
Thank you. Any other questions for Ms. Ledger? Seeing none, we're going to move on. And next is Mr. Sifft.
I won't take 5 seconds. I'm here just to answer any questions. Phil Sifft, 1118 Hamels Point Road, POC 1HO, Mike here. I guess I have one comment is that I think I'm not sure of the rules when it comes to TSSA and the fire department, but I do think that TSSA does rule when it comes to safety factors and not mitigating at all the fire chief and their responsibility. I think the TSSA is here to dictate when things are safe and unsafe. And if it's unsafe, I think they'll not let them sell fuel. They won't make them not park. And so I think that's the different issue here than probably people are speaking about. It's a fuel issue. And if it's a hazard issue, it's a fuel issue, not a parking issue. And that's it. I'm here to answer any questions.
Thank you. Any questions for Mr. Sifft? Seeing none, Ms. Cope, please. State your address, please, and you have 2 minutes.
Hey, Melissa Cope. My office is at 61 Joseph Street, Port Carling, POB 1J0. And I'm just here trying to make sure I can clarify some of the issues with the lease and the parking that have come up either in the submissions or in questions today. So I guess for me, firstly, again, the application isn't about development at Mortimer's Marina. Those owners aren't here to talk about development. We're talking about development on Meadow Island, and any sketches were included to show where these parking spots that are the subject matter of the lease are located and where slips are located. Secondly, it's existing parking at the Mortimer's Marina. The parking lot exists, it has existed a long time, and we've secured parking at certain spots in the existing parking lot. Both sketches show, the sketches and the agreement show that the existing parking lot, and that's what I've been told by the owners. In terms of the boat slips, we have existing boat slips that exist today that are part of the lease. If those are redeveloped, so I think there was a suggestion that they might be removed and relocated on the property, not 16 new slips created, something like that. It's the redevelopment of the existing slips into a different configuration. Then we've identified what slips in the new configuration would be going to the parties. So it's not new slips that aren't there. It's either these existing ones or the reconfigured ones, which seems to be part of one of the questions that concerns. The other question I have is about the location of the parking spots that are the subject matter of the lease. So I had sent a submission to Mr. Soya and I sent him a clarity copy of the schedule that shows the location of where the car spots 5, 6, 7, 8, 9, and 10 are located. I don't know if you have it. I printed
20 seconds, Ms. Cope.
I have copies of where these are located, and they're on the other side of the aluminum building, not near this fuel tank. So it's on the other side of the building where the car spots are that are part of this lease agreement. So, and again, the parties take position that they have a binding contractual lease for existing spots at Mortimer's and existing boat slips, and that they fulfill their obligations to prove that they have long-term parking.
You're out of time. Thank you very much. Anyone with questions for Ms. Cope? Oh, sorry, Mr. Councilor Bosenworth.
I wonder if we could see the revised sketch of where the, I believe it's a new location for these parkings that Ms. Cope was referencing.
Ms. Cope, if you want to. Yeah. Sorry, you have to go to the microphone.
Give you a copy, sorry. And I should clarify, it's not.
Yeah.
Oh.
Sorry, let me ask a question. Is it, I can't see who was talking back in the corner, but is it, if you. I think that would be useful. It's new information.
It's not a new sketch. It's the same one. It's just the clear copy because the lease was back and forth and scanned in PDF with signatures. So it's the same one, just clear about where the location of the parking spots are, because that seems to be a big issue. What parking spots?
Mr. Sharp has joined us, so I assume you have some light to shed.
Thank you, Mayor Kelley and Council. I believe Mr. Soya is working on getting that sketch available for screen share, so just bear with us for a moment. Thank you.
Thank you.
So on the screen is just a clear copy of the schedule that's attached to the lease agreement. So the lease agreement is specific that the car spots being rented are 5, 6, 7, 8, and 9. They're on, I guess, the lower right-hand corner to the right of the aluminum clad building. Those are 5 through 9 are the spots being, and then car spot number 10 is the 6th spot. Can I give you that?
Councilor Nishikawa, you have a question?
Yes, thank you. Just with the presentation from Ms. Ledger and now following this up, I want to confirm that what I think I'm hearing, and maybe this question would go through you to David. It looks like we're talking about a policy change. And this application was applied for under the current policy that we have that says that you can make an agreement with a marina. But I think I'm hearing, is there a request for a policy change? Because that's a bigger discussion. And I'm concerned that this conversation has gone to something that is not in our policy.
Yeah, and I'm going to go defer to Mr. Pink. He's on screen. Mr. Pink, please.
Thank you. Through you, Your Worship. I can't speak to whether Ms. Ledger or any of the delegations are requesting a policy change, but I would like to clarify that yes, this water access issue was debated and discussed at length through the official plan review process. As the municipality was cognizant that there are concerns. There are an extensive number of water access properties remaining in our township with remaining development potential, lot creation potential. And accessing those properties is becoming an issue due to the limited resources of marina and limited space available. However, you will recall that we received an extensive amount of submission from water access island owners wishing to preserve their rights. Now, the adopted official plan has expanded and has extensive policy about different options available by which to secure access, whether that be mainland, owning deeded mainland property, easements over mainland property, waterfront landings, marinas, or the permission to allow any waterfront residential owner to provide access to up to 2 island properties. However, the said new official plan certainly does not prohibit or cease the permissions to subdivide island properties. Our current official plan and the newly adopted official plan both allow water access properties to be created, provided parking and docking are secured. And again, municipalities of the opinion or staff are of the opinion that there is a lease with a marina property where they've entered into a lease to provide parking and docking facilities, and that property is permitted to do so. What I would also note is in the newly adopted official plan, I think to attempt to address the concern somewhat, you will recall that the lot requirements for island properties have been quite a bit more stringent. We have increased both the frontage and the acreage requirement, which will reduce the development potential of said island properties. But certainly I do not recall any intention from council to prohibit the future creation of water access properties.
Thank you, Mr. Pink. Councilor Kent.
I have a question for Mr. Morgan. Can I do that?
Sure, because I didn't give you a chance earlier.
I'm just trying to understand the difference between what Ms. Cope said and your plan on the parking. I was confused. And she said it wasn't consistent. I thought yours was consistent with hers, but I'm not sure. It sounded like she found some other parking spots in different places.
Well, on other parking spots, there are 2 basic math issues here. The first is all of those spots, including the ones which Ms. Cope pointed out in the lower right-hand corner of her map, those are in the 23. If we eliminate the 14, there's 9 left, and those 9 have to be allocated for other purposes. They're not available. The other basic math point is that you require 2 parking spots per slip, and 6 are under the Mortimer's side of Mortimer's landing side of the lease, and 6 are under the Mortimer's marina side of the lease. If the 6 are wiped out at Mortimer's Marina, those parking spots under the lease cannot be allocated to the Mortimer's Landing. They're wiped out. Therefore, the way the lease works doesn't satisfy your requirement that there be 12 parking spots for the 6 slips, because there would only be the 6 on the Mortimer's Landing side.
Just one last follow-up, which is that.
Sorry, excuse me. Ms. Cope had her hand up. I think because her specific issue was referenced, she deserves an opportunity to rebut or to speak to it at least. Sure.
So I guess there's still confusion. The actual lease that was submitted and that the township has copies of were for those parking spots 5, 6, 7, 8, 9, and 10 on that schedule. I'm here to show you where those are located. It's not new spots I've created. That's what the lease is for. We included the schedule to show exactly what spots are the subject matter of the lease, and they were the ones on the schedule 5, 6, 7, 8, 9, and 10. I didn't create them new. They weren't new created today. I have the lease here if you'd like to see it again, but those are the spots that are the subject matter of the contract for the rental of parking spots.
Okay, thank you. Councillor Kent, did you have another question?
The only question I had for Mr. Morgan. The implication was even if they gave them those spots, 6 other people would be kicked out. They can say they got the spots, but if the 6 that you are talking about are not viable, they'll find 6 other spots by taking older tenants and saying, we don't have a spot for you anymore.
That was Mr. Pearce's point.
That's okay. Just wanted to make sure.
Thank you. Councillor Edwards, and we're still asking questions of the delegates. Okay.
Question. I guess I'm not sure who it's to. I'll ask Ms. Cope, and maybe Mr. Pink can answer this as well. So you have a binding lease. You have asked for letters in the past. This is something that's new and that's more solid. What would happen if they can't supply you with the parking spaces? And I thought it was 12 parking spaces, not 6.
Is it on? Okay. So when they started this application, I think it might have been 2021, there was a 1-page agreement or lease. And I know that in the past, a 1-page something that said, we have parking spots and they're for you, you can have them, you can proceed. That's not acceptable anymore. Since the time of that original hearing date, the applicants had been in negotiations with Mortimer's Marina to secure the requirements for the parking spots and docking that the township said that they needed in a more secure lease. So we worked with Mortimer's Marina to determine that we can get 6 parking spots at the one site, 6 on the other, and 6 boat slips. And that required 2 different landlords to be involved in the lease contract and for the applicants to be other parties. We went back and forth about how long the lease could be, options to renew so that it was for a term longer than 5 years. So we have renewals up to 20 years so that there's no suggestion we'd be offside of Planning Act rules. We have a method, an assumption agreement in there in terms of when the lots are created and eventually sold or transferred to different parties, how we transfer the parking rights, and Mortimer's Marina agreed to extending these rights to the next owners of this property for the remainder of the term or for different terms. But as you say, it's still a contract, it's a lease, but it's under understanding that these legal contract, they have specific rent periods, specific spots delegated to them, and it's binding on the parties. So I can't really comment on, should they lease to this person or that person, because I think that's really a commercial private property matter and not something for us to discuss here. In terms of what parking spots are not, it's been my understanding the whole time that Mortimer's Marina exists. This is the parking area that exists today. We have spots that exist that have been assigned to this party. If there's any problems that have been suggested for like TSSA or fire, that would be dealt with by TSSA, who is the authority to do with the fuel. And then there's obligations for the fuel. They decide what barriers or signage is required. Really, I guess the focus for the applicants is this was one of the requirements to have a complete application to move forward. It took us a long time to get here to work to have the right number of spots for parking and docking. We took this long to get it. We arranged it. We provided it to the township. The township had their own independent solicitor review the lease agreement before we ever came to here. It wasn't something slapped together. It's not a one-page thing. It didn't happen quickly. It took a lot of time and effort to get to this point. So I'm happy to discuss the terms of the lease as much as possible, respectfully for everyone. But I guess the applicant's thing is the applications on the development of the island property. The lease is just one of the conditions to have a full application to move forward. In addition to that, the requirement will be that they have the consent agreement as one of the conditions that require that they will continue to have long-term parking and prove it to the township. So if this lease doesn't exist, or if a future purchaser wants to have a lease somewhere else, or they own their own landing, or they use a float plane, or they have a helicopter, however they access the island, because it's a possibility. I have clients that do all those things. Then they would be subject to the consent agreement and have to prove to the township at that time that they also still have long-term parking and docking.
Thank you. Any other questions? Councilor Edwards.
Okay, I see Mr. Sharp on the screen there, if he's still there. Mr. Sharp, does this agreement satisfy you? And that's because if it's binding, I think it's all legal. So what is your thoughts on that?
For you, Mayor Kelley, and thank you for your question, Councilor Edwards. I was just going to clarify the fact that there's a condition of consent requiring that the owners enter into a consent agreement with the township, wherein they would need to demonstrate at all times that they've secured adequate mainland parking and docking facilities. And Ms. Cope had addressed that in response to your question. But further to your question, Councilor Edwards, as Mr. Pink had already indicated, staff are satisfied at this point with the lease agreement, and we're comfortable that the material that's been submitted conforms with section B 5.24 of the township's official plan, which speaks to providing access to new waterfront lots. Thank you.
Thank you, Mr. Sharp. Unless anyone has any more questions specifically to any of the delegates, then we're going to move on. Thanking everyone for their input on this file. It's going to come up later on in the afternoon, probably around midnight, and we'll have an opportunity to hear the debate at that point. I'm going to move on to the next one, which is also a Sifft file. It's Mr. Silcox. Is he joining us by Zoom? Perfect. Mr. Silcox, welcome. You would please start with your address, and then I would remind you, you have 5 minutes, and I will call out about 30 seconds before the end. You're on mute, sir.
Sorry about that. My address is 1037 Christie Point Road, back here. My property runs from Stills Bay out to Hamels Point Road. And I'm very, very familiar with the situation. I've gone by it. I've seen the barge moored at the temporary dock, which I have heard discussed previously. But I wish to thank councilors for letting me speak regarding my objection to certain issues contained in this application, which is now under consideration. This revised application seeks approval for a single-story boathouse with 2 interior boat slips and a zoning allowance regarding a total dock width from 50 feet to 64 feet, or a 22% increase with an additional outside boat slip that will be 66 feet in length. Since the current zoning allowance is for a dock with 50 feet, which should accommodate the mooring of 4 boats in addition to the 2 interior boat slips, or a total of 6 boats, there has been no compelling reason put forward or demonstrated to allow an outside slip, especially with a dock length of 66 feet. What I do object is the applicant applying for a proposed dock being widened by 14 feet or 22% with an outside boat slip. It seems to me that after careful consideration, the current zoning should not be a guideline. After all, it's called a zoning bylaw. And this guideline, or actually should say the zoning bylaw, should be adhered to unless there has been a compelling reason to change the zoning rule. I would also like to draw council's attention to all presentations as shown under agenda item zoning bylaw 9B4, which are on pages 286 to 316 of this 378-page report, which support or object to the current application. Currently, the majority of these presentations have voiced their clear objections to the application, which is under consideration today. Thank you once again for allowing me to register my objection and making this presentation.
Thank you, Mr. Silcox. Does anybody have any questions for Mr. Silcox? No, I'm not seeing any, sir. So thank you for your input and have a great day.
Thank you so much.
Okay, we're going to move on to 2 more presentations of 5 minutes each. First from Ken Pearce, followed by Susan Eplett, both on the procedural bylaw.
I think this is on. Thank you again, Mayor, councillors and staff. Just wanted to speak briefly about the proposed updates to the procedural bylaw. I think it's a very good effort, but we do have a couple of comments. Ken Pearce, Director and Secretary, Friends of Muskoka, so I'm wearing a little bit different hat for this one. 2232 Muskoka Road 169, Gravenhurst, Ontario, P1P1R2. I've delegated not only before the Township of Muskoka Lakes, but also Gravenhurst and the district, various councils and also committees for TML, the Planning Committee, and for Gravenhurst, they call it Planning Council and the District Muskoka Council, Engineering and Public Works Committee, and Community and Planning Services Committee, and also delegated public meetings before them as well. The public meetings, sometimes there is no timeline for how long speakers are allowed to delegate, but generally they're limited to 10 minutes. So I just want to share some experiences with other jurisdictions, other municipalities. Council committee delegations are generally limited to 5 minutes or 10 minutes. I've got one in a couple of weeks in Gravenhurst for, they call it Planning Council, and I'm allowed to speak for up to 10 minutes. I can attest to the fact that 2 minutes is difficult. Rarely enough time to delegate on complex matters or multiple issues. It's by the time you introduce yourself and introduce the topic, sometimes you only got 1.5 minutes left. I can talk pretty fast, but to be honest, 5 minutes is often even not enough. I acknowledge that we can and often do make written submissions and contact counselors in advance of meetings as well. But I don't think understand our difficulty contacting 10 counselors is not easy. And I don't think you want us calling you all the time for various matters. So if we can delegate and, talk to all of you for 5 minutes, I think that works quite well. Fortunately, this term of council so far, we haven't had the need to really reach out to you all that often and call all of you and keep doing that. So I guess that's to say a good job and appreciate that. The second point is the timing of the request to delegate. The 5 minutes, I think, would make sense irregardless of when the request is made. Previously, you would be granted 5 minutes if you made the request at least 7 business days before the meeting, which is generally before the agenda comes out. So you would need to know that sometimes it's difficult to know that your matter will be on the agenda to get the 5 minutes. And you're allowed 2 minutes if you make the request approximately 24 hours or 28 hours before the meeting. I think it would make sense to do away with that. And I think there's been some discussion with the clerk and others that might make sense. I recently got caught out, as I said, on the Sifft Donaldson matter for Maida Island. I thought I had 5 on June 15th and I only had 2. And I had to scramble and I did apologize for that. I really didn't. That's why I'm back today, just to finish my comments on that one. And I don't like to do that, quite frankly. I was caught a little bit short on that one. So thank you. And if you have any questions, I'd be happy to answer them. And we've got Susan Epplett this time from the MLA up next as well on this.
Thank you, Mr. Pearce. Anyone with any questions for Mr. Pearce?
Thank you.
Seeing none, we'll call on Ms. Epplett, please.
Thank you, Mayor Kelley and councillors and staff. My name is Susan Epplett, 45A Walkers Road in Rosso. And as Ken mentioned, I'm speaking on behalf of the Muskoka Lakes Association. So the MLA really appreciates the creative proposals that Director Pearce put forward in her report last month to improve the procedural bylaw. It's an important bylaw since it establishes how you carry on your meetings and how the public is able to provide our input that we hope can be helpful when you make your decisions. I'm going to be making 4 comments. Firstly, the MLA supports the proposed amendments, providing 3 types of meetings for council and committees: hybrid, electric, and in-person meetings. Being able to hold meetings in these 3 different ways gives flexibility to accommodate different types of situations. The MLA, though, encourages limited use of the in-person meetings when there's no live streaming. Because that would limit the public's ability to monitor and participate in meetings, which we think is an important part of the whole process of making decisions. Director Pearce suggested this option only in limited situations, such as when meetings are held outside of council chambers or where this is a ceremony, and we think that makes a lot of sense. Second point is the rules around public delegations. So when the public wants to delegate on a new matter that is not on the agenda, we agree with the proposal that they should submit a request 7 days before the meeting, and that they should provide the material well in advance of the meeting as well, so that it can be, the request can be reviewed and the meeting material can be incorporated into the agenda. However, and I apologize, I didn't realize this until driving here this morning, but there's a proposal that the request to delegate be made 7 days before the meeting and that the meeting material be submitted 5 business days before the meeting. I think that's still the proposal. Dr. Pearce is nodding. So if that's the case, I think it works out that there could be a situation where there's an intervening public holiday where you have to submit your material the day before you request to delegate. So my suggestion, an easy solution would be to say that the request, both the request and the material, have to be submitted 7 days before the meeting. I think that'll fix it. I also wanted to mention that since this type of delegation would involve a new matter where there's no staff report, you may want to consider allowing the delegate to speak a little longer than 5 minutes in that situation. For example, last month there was a presentation by the ramps group, and I could see that there was lots of interesting things to come forward. So maybe 10 minutes, just floating that. When the public wants to delegate on a matter that is on the agenda, the MLA agrees with comments made by Mr. Pearce that the speaking time should be 5 minutes, not 2 minutes, and that to eliminate uncertainty and confusion, it should always be 5 minutes. That also gives a chance for the delegates to make a more informed, fulsome presentation. My third point is we appreciate that staff are looking into improving the information for the public to learn about how to delegate, and also improving the process for requesting to delegate. Finally, the MLA supports the proposal to permit council or committees to create ad hoc working groups from time to time. We agree with Mayor Kelley's rationale in his presentation at June's General Finance Committee meeting about the benefits of working groups over standing committees, especially in a situation where there's a specific question or specific issue that needs to be looked into within a certain time frame. And in these situations, we also think it would be helpful to be able to draw in members of the community who may have expertise to help with that issue. But this working group model was used successfully, as many of you know, in the township's official plan review, in the Manette official plan review, and also in the recreational master plan review. And so we think that working groups can be an efficient and streamlined use of the township's resources. Those are my comments. Thank you very much.
Thank you, Ms. Eblett. Does anyone have questions? Seeing none, thank you very much. Okay, we have basically one matter, I believe, left. We have several delegates scheduled to speak. I'm going to start with the first one, 5-minute delegation from Mr. Hansen. Sure. If you want to I don't see him. Oh, thank you. You're online. What? Oh, I thought that was his hands.
So are you waiting for me? Hello, can you hear me?
Mr. Hansen, it's Mayor Kelley. I'm going to be chairing this. I'm going to tell you right now, we have, after some consultation with the clerk, decided not to put your presentation on the screen. So you can speak, but some of the material that was contained in the presentation that we just recently received, we have determined is not appropriate to be put up. So you will not be able to refer to it as a prop or as something to point to. And I would also ask that you please respect the timelines, respect the chair, and stay respectful of anyone you refer to or any of the comments you made, or we're going to unfortunately just have to keep it really short. So with that, you have 5 minutes, I believe.
Sorry,
5 minutes.
Can you explain why this material is not admissible?
Because we determined that it was not. We're not going to get into it right now because to do so, we would have to talk about it.
Okay, you ready?
Yes, sir. Go ahead. You have 5 minutes. Please identify yourself and give your address.
Brian
please.
Hansen, 323 Ballston Drive, Oakville. So I had a picture which showed a picture from the water from the Jennings sale listing and compared that to the before the Everbucks bought it, and compared that to the Everbucks current status. And it shows a drastic difference in the tree coverage. And it's pretty clear from that picture that the Everbucks clear cut the property, trimmed up the remaining trees, damaged them, built up the patio, enlarged boulder retaining walls, and added a pathway. Respect to the amended solution, our perspective is as follows. Section B 551 states a natural undisturbed buffer is required at the water's edge to meet a target of 50 feet in depth from the high water mark. This should be the requirement when deciding how much hardscape to remove. Otherwise, why do we have this regulation? With so much built form, there's no room to have sufficient lakefront or vegetation. Currently, there are two pathways to the water. There's a picture from the Jennings sale listing which shows that Jennings only built one pathway. The Everbucks added a second pathway. You can also notice the difference in the walls in this picture. Site plan agreement states that only one pathway is permitted and the material should be permeable, not the current granite. The MMLA report agrees with this. Thus, one path should be removed and renaturalized, and the granite stairs should be replaced with permeable materials on the remaining path. There's no need or justification for two paths on such a small property. We also suggest significantly reducing the size of substantial retaining walls and patio and replace with natural buffers. The picture that I had in my report illustrates that the Everbucks built the large retaining boulder walls, not Jennings, and expanded the patio footprint. How can trees and shrubs survive with this amount of hardscape and runoff? There's a picture I included, which I'm not sure why that's excluded because it's in the report. So I'd like to know that in an email after this, please. That's included in a report of one of the consultants, which shows erosion and runoff from the patio. Also included a picture from the consultant's report, which again, I'd like to know why it's not included. This shows a oval shaped stone patio near the shoreline and gazebo, and we suggest removing the gazebo in this patio. According to the MNLA report, encroachment of patio areas and stone pathways within 15 meters of the lake, including a widening of the pathway where the gazebo is located. These features have resulted in localized changes in the permeability of the landscape, according to the MNLA report. Another picture, I'd like to know why it's not included in here. That's from the consultant's report. It says, it suggests that the significant amount of rock in front of the sleeping cabin and plant shrubs is removed. The reforestation, so again, I don't know why these pictures are provided by the consultant. So I'd like to know in writing. You can copy my lawyer, who I think you have his email. The reforestation plan and the maintenance of the plan should be registered in the site plan agreement. A typical renaturalization project includes ground cover, ferns, trilliums. We'd like to know why ground cover is not included in the plan. Many of the existing trees are suffering from dieback, which is a deterioration of health in the trees due to excessive trimming that was undertaken. Why was this not addressed? New trees, additional to existing tree planting, the tree planting plan should be planted beside those that are dying so that we have replacements as these prematurely die. In the meantime, these trees should undergo stem injections to prolong their life until the new trees are of similar size. We had the picture and compared it to what it was before, it'd be very clear what's gone on here. Why was a fish habitat study not performed here? While Lake Rosso is no longer classified as a vulnerable lake, Portage Bay could be more vulnerable to change according to the Poirier report. As they say, highly sensitive water bodies were those in which the model suggested that new development had the potential to input more phosphorus than the water body might be able to sustain, which in this case related to East Portage Bay, being a relatively small and protected embayment with water quality conditions that differed from and could be more vulnerable to change than Lake Rosso as a whole. The MNLA report states that they observed type 2 fish habitat, but did not mention type 1, which was observed in the Riverstone report. Shouldn't we ask why this is? Could it be that it no longer exists? If it doesn't, that's a big problem. How will
30 seconds, Mr. Hanson.
How will this plan, that's not what I've got on mine. I've got 45. How will this plan be monitored after it's completed to ensure compliance? Owners taking a picture once a year with a timestamp for 10 years and sending to planning departments commonly used to ensure compliance. Will there be a replanting provision when the existing plantings are monitored? What's being done about the clear cutting of the trees behind the dwelling? Again, another picture from the consultant's report. As I mentioned in my first delegation, email below confirms that a certificate of pending litigation between Hanson and Jennings was on title in 2016. This was a claim against Jennings, outlined many issues with the property, which the Everbucks and their lawyers would have.
Mr. Hanson, we've given you even your full time with the extra 15 seconds. So we are at the end.
I'd also like to know in writing why Stephen Fahner had 8 minutes in the last session as an ex-employee of the town and an agent
Thank you very much,
Why,
Mr.
why there's a,
If you can still hear me, we will be putting your presentation in the public record, but after staff have had a chance to redact language that we deemed inappropriate. Unfortunately, it came in too late for that to happen before this meeting. So it will form part of the public record, but not until after we've had a chance to redact offensive language. Sorry, moving on. We are moving to Elaine Hanson. Is Elaine Hanson also going to delegate?
Yes, I am, Mr. Chair.
Perfect, thank you. We'll wait till you're on camera.
Okay. There we go.
All right, we're going to give you 5 minutes. I believe we have your address. I would remind you that we will call out 30 seconds beforehand. And it would be noted if you just move forward from where Brian Hanson left off and not repeat the message. Thank you.
Thank you, Councilors, Chair, and Muskoka Lakes administrators. I would like to show a 20-second video, if we could put that on now, of the intact shoreline on Portage Bay today, followed by the Aberbrooke shoreline. Do we have that?
1 second. I think they're just loading the video, if I'm not mistaken.
Okay.
Yeah. Okay, go ahead if you want to narrate it. It's running right now.
You know what? You've taken up my screen here, so I'm just gotta go back.
We can hear you.
Okay, perfect. So after seeing this, are we to believe the Poirier report of 2023 stating that this property is really in character with surrounding properties? So that was the Poirier report 2023. So language really does matter. Next, please find attachment number 1, which we received late last night from 2016 Jennings listing. See the abundant shoreline buffer, and then see attachment 2 and 3. Do we have those attachments?
They're just, so we have them? No, apparently we do not have them.
So those are critical to this presentation because they will delineate the 2016 property as it was listed.
We just stop your clock for 1 second while we find out if that is available to us. Was that part of the package that was delivered up just before the meeting?
Yes, thank you.
We haven't had a chance to go through it. And we had decided not to post it on the screen while we were working through it. As I had mentioned earlier, there is some language that will be redacted and it will be posted and form part of the public record after we've had a chance to have staff go through it. But I believe it came in just before the meeting and we did not have a chance to do that in advance.
Oh, okay. This is public record pictures, so I'd very much like it for all the councilors to take a look at this. This was the 2016 listing of the property. It's an immense, vast, and very abundant shoreline buffer, and used in large part, if you take a look at attachment 2 and 3, to remove any doubt about who clear-cut the property, who built up the stone services without permits, and the outrageous stone walls and shoreline destruction that occurred following the purchase of the property. Unfortunately, you're not going to see attachment 4 either, which is unfortunate. I thought we're led to believe that we would have this on here, but this is another, attachment 4 is a picture of the hot tub. But it's another example, and I quote from the town planning department report, the hot tub is built into a rock retaining wall of some height. What we're doing is minimizing. It's actually in violation by 14 feet of the required setback, not a couple of feet, 14 feet or roughly 40%. The relocation of such is not a debatable issue. And please do not continue telling people that the removal will create more damage. The land itself is incredibly resilient. However, the point here is how we describe narratives to council is critical for decision-making and ultimately to our democratic process. These are minimizing statements and they're flagrantly inaccurate. On June 2021, again, I had a great attachment, which I'd really like that to be part of public record. I approached a builder who is readying to build another structure on the Aberbush property and create his own path to the lake. I very respectfully asked that he pay attention to the root system of some of the maples and pines that are decades old on the north side. I called Mr. Aberbush himself to advise. This is the result of that conversation an hour later. Now, what you can't see, unfortunately, as council right now is a probably 10 to 15 foot trench that cuts through the root systems on the north side that clearly lead to the next attachment, which you can't see, which is pine trees dying over a period of 600 days and 2 years. Mr. Chair and council members, people are talking, and while vast sums of money are being used to justify our actions, in the end, people of this region are watching, and we are spending money to justify decisions rather than enforcing our bylaws, which in this case were never enforced, and using the province to justify the health of our lakes, rivers, marshlands, soil quality. So councils and
30 seconds, Ms. Hanson.
townships, thank you, turned down buildings for violations of 5 feet, never mind 75 feet of relief on buildings, as is the case here. We are establishing a dangerous precedent, which will accelerate further violations and abuses and ultimately affect the legacy of this area, continued water quality degradation. Thank you.
Thank you very much. Any questions for Elaine Hanson? Seeing none, thank you very much. There are, I believe, 2 more. We have one just marked as representative of Elaine and Brian Hanson. Is there somebody who is representative of Elaine and Brian Hanson? You don't believe they're attending? Okay. That's one. Last 2 I have is on behalf of Mr. Aberbush, we have Peter Hungerford. Is he on? There he is. Mr. Hungerford, welcome. Just 2 minutes. This is a 2-minute delegation, and we'll let you know when you're down to your last 30 seconds. And you're on mute, by the way.
There we go. Can you hear me now, Mr. Mayor?
We can. Thank you.
Good. Thank you, Mayor Kelley, members of council and staff. Again, my name is Peter Hungerford. I'm a planner with Marie Poirier Planning and Associates at 44 King William Street in Huntsville, P1H 1G3. And I'm appearing again, this time before council on behalf of our clients, the Aberbucks, who have made application for a rezoning to recognize a number of deficient setbacks on the property. And that application has been supported by your staff with a recommendation for approval, subject to some conditions. In conjunction with the application that was submitted to Planning Committee, our clients, on a goodwill basis, had Muskoka Landscaping prepare a landscaping plan that was intended to show their good intent on how the shoreline might be revegetated. Admittedly, the plan has not been approved by staff, and we expect that over the coming months, it will be reviewed, and eventually we'll get to a point where it can be approved. The Planning Committee also recommended that further study be directed to the property, engaging again Hutchison and our own environmental consultant, Nielsen, to look at the hardscaping on the property. And having talked to our environmental consultant and my client, we're certainly prepared to engage in that supplementary review. So
30 seconds, Mr. Hungerford.
Thank you, Mr. Mayor. So on that basis, I would be asking council to approve the recommendations of planning committee so that we might move this matter forward into its next step for further review, and I would expect to report back to council. Thank you very much.
Thank you, sir. Does anyone have questions for Mr. Hungerford while he's on the line? Seeing none, I would thank you very much and wish you a happy afternoon.
Thank you,
The
Mr.
last
Mayor.
one, the last speaker that we have on this matter, on all these delegations, is Arnold Aberbush. Welcome, sir.
Hi.
You could start with your address and then you have 2 minutes and I will call out 30 seconds. Thank you.
It will take only a minute. Arnold Averbach, 37 Vaughan Boulevard, Thornhill, Ontario, L4J 3N8. I would just like to address the environmental aspect of our zoning bylaw amendment application. We have worked closely with the planning department for quite a while now, and I would like to reiterate our intention to follow recent 2 environmental consultants reports, including the upcoming additional assessment, as Peter mentioned, as per last council meeting decision to restore and to renaturalize the water shoreline. We have an extensive planting plan constructed based on the environmental experts' guidance and recommendations. We are committed to put it all in place and to be completed to the satisfaction of the township. That's all I need to have to say. Thank you very much.
Appreciate that. Anyone with any questions while we're here? No. Seeing none, thank you, sir. I appreciate that. Thank you. I think we probably should take a break. It is, what is that, 7 minutes after? Why don't we come back at 20 minutes after, in 12 minutes, 20 minutes after, according to that clock. Thank you. Okay, ladies and gentlemen, welcome back. Council, I think, well, we certainly have quorum. I think we're all here. We're going to move on to the consent agenda, item 6, and work through basically three matters here. The first one, we have, I've been told, a couple of items to be pulled from the consent agenda. And I understand, Councillor Mazan, you want to speak to a couple of them?
Yes, I'd like to please pull from our General and Finance Committee action items from last month, pulling items number 6 and 9.
Thank you.
Thank you.
I also have a note that Planning Department has requested one be pulled. Someone verify that for me, please. Here we go. Mr. Sharp or Mr. Soya?
Thank you, Mayor Kelley. I believe you're referencing the Baker consent conditions.
Yeah, that's it. Item number 4 from planning. Yep.
Thank you.
Okay. So that has been noted. Okay, then I'm going to move the first resolution or read the first resolution, which is taken into effect those 2 changes. Moved by Councillor Bosamworth, seconded by Councillor Burry. Be it resolved that the mayor and council adopt and enact the following minutes and recommendations contained in the July 12, 2023 consent agenda and direct staff to proceed with all necessary administrative actions. Number 1, June 14, 2023 General Finance Committee minutes and action items 1 through 5, 7, 8, and 10. June 14, 2023 council minutes. And number 3, June 15, 2023 Planning Committee minutes and action items 1 through 3 and 5 through 16. Anybody have any comments, questions? I'll call the question. All in favor? That carries. Thank you very much. I'm losing my voice. I need to ban this. Thank you. Okay. All right. Don't let me miss this. Next resolution that we have is moved by Councillor Mazan, seconded by Councillor Nishikawa. Be it resolved that staff be directed to report back with a terms of reference for a working group to address the request from Justin Edwards to rename the Bala Arena in honor and memory of the late Peter Cowan, as well as a term of reference for a working group to investigate potential policy changes in relation to asset renaming and naming in memory for committee's consideration. Anybody with any questions? Councillor, Zavitz first. No,
Thank you.
mixed up.
Then through you. So I'm just wondering, being that I seconded that a month ago, I don't understand what the reason for it coming back would be, because it sounded like what you read was what you'd already read. Thank you.
Thank you. I'm going to, sorry, you were saying, what to Councillor Mazan?
Thank you. I think the clarification required is why did I pull it? And I think that perhaps it's appropriate for us to hear from staff, because I think after our meeting, that staff did follow up with the family. And I think it might be appropriate for staff to just provide a possible path forward that is appropriate and respectful to all parties at hand. So perhaps either our clerk or CAO could provide some context on this particular.
Well, in summary, for my edification, it was pulled so that we can reconsider in light of whatever we learned or determined through the conversation with family.
Correct.
Okay,
Thank you.
go ahead, Madam Clerk.
Thank you very much, Mayor Kelley. In response to the question, yes, staff did meet with the family member of the late Peter Cowan, and based on the resolution that was passed to strike a working group, staff do believe that there might be some other paths forward by working with the staff or with the family directly. So rather than striking a working group, working with the family members directly, and then coming back to this table with some potential paths forward once we've had a chance to talk to them and see what they are amenable to.
Any other questions? All right. Sorry, Councillor Zabas, go ahead.
Thank you. Thank you for that explanation. So one would presume then that the person who brought it forward, Justin Edwards, was informed.
He's aware. So in regards to the policy, we were required to reach out to the family. So we did reach out to Stephanie Cowan and met with her because she had to sign an affidavit and make sure that she was on board with everything. So in consultation with her, we had a conversation with her and said, would you like to work with us and find a good path forward? And she agreed. So based on our conversation with her, that this was the recommendation.
So if I might just say a supplemental. So we did talk to Justin Edwards, who brought this forward at the beginning. He knows that this is going in another path. Not that he's good or bad with it. It just, he should be aware.
To answer your question, I did email with him this morning. He was asking what the path forward was, and I said I would be in contact after this meeting. So he knew about that potential, but he knew that it had to be ratified at this table and it could change. So it just depends on what the decision is here, and I will be in contact with him as soon as this meeting is over to let him know what the decision was.
Okay, if I might, I just find it strange that we had a mover and a seconder a month ago, and this thing comes back on. I guess it's being discussed here, but we have two different movers and seconders, as if the first one just somehow evaporated. I don't understand that. Thank you.
I don't certainly have an answer to that. I wasn't sure the answer to that. Councilor Nishikawa, can you answer that?
Well, mostly there was a presentation. We had a direction as committee to move it forward to council. This is the response from that and learning more information, which we asked our staff to look into. This is the response. As far as who second and first and all that, it always alters every meeting. Like there's no, consistency in that particular case. But I believe that we followed through with what we were asked, look into this. And it's not done. It's not a dead deal or anything like that. There's going to be more to come, I would suggest.
Thank you. No, I guess there's two separate issues. The process that was followed in terms of consultation with the family was called for by the current policy. There was an affidavit, I believe, of Mr. Cowan's widow that needed to be completed. So that part of it would go on per the existing policy. And as we said at the beginning, all of these resolutions are populated in randomly, I believe, anyhow. So this comes to council with the two names that happen to get populated in it, Councillor Mazan, Councillor Nishikawa. Okay, that's fair.
I think just to add some context to, I think just because being chair of general finance and because of the sensitivity of this matter, I think that staff reached out and said this this is a very sensitive topic, and I think we all have to be very mindful of that. And I think the approach that staff have suggested is let's do this properly and thoughtfully with respect to a really sensitive topic. And are trying to create an appropriate path. And I think it is as innocent, as simple as that, at least from my perspective. So I think that the comment or the question I've heard from staff is there might be an amended resolution to create that path forward. And I would imagine that once that's done, that every stakeholder, I guess Mr. Edwards, as well as the widow and her family, would also understand what the appropriate next steps would be. Would be my expectation, I guess.
Okay, thank you. We have actually a subsequent resolution to postpone action on that one that had just been read because we need to direct staff to come back with various options, having completed whatever they need to complete under the policy. Moved by Councillor Mazan, seconded by Councillor Zavitz. Be it resolved that the matter of creating a working group to rename the Bala Arena and investigate policy changes in relation to asset renaming and naming in memory be postponed to allow time for staff to work with the family of Peter Cowan and come back with options for consideration. Any questions? All in favor? Thank you very much. That carries. Next one is action item 9 that was pulled separately. Moved by Councillor Mazan, seconded by Councillor Burry. Be it resolved that the amendment to procedural bylaw 2019-079 as attached as Schedule A to report LS-2023-22 be approved, and that an amending bylaw be forwarded to council for final approval. And that amendments to policy C-GC-15 council and standing committee meeting agenda as attached to report LS-2023-22 be approved. And that policy C-GC-07 council and committee and ad hoc committee principles and policy C-GC-08 public delegations be hereby rescinded. So we're not going to vote on that one either because of a potential or discussion on some potential amendments. And Councillor Mazan, I'm going to call on you to bring that up.
Yeah, thank you. I think I pulled this for obvious reasons. I think we've had delegations from the public. I think we even heard yesterday at our procedural bylaw session that there was interest in perhaps amending some of the discussion from last month. So I simply brought this back to open up that conversation to see if there's interest from this committee before it might be amended. So that was my simple thing, and I will turn it back to you, Chair. Thank you.
Thank you. So is there any discussion on any of the material that we heard on changes to the committee rules, council and committee ad hoc rules? How do we want to do this? Move it forward? Just have a discussion on that, or? Okay, so it's a time limit for delegations, first and foremost. Anybody have any feedback on that? Okay, Councillor Edwards.
We have heard today that we should be limited to at least 5 minutes. 2 minutes is not enough. I would support that. As I had said yesterday in the meeting, to somebody to drive up from Toronto or from their cottage to speak and they only get 2 minutes is an insult. Thank you.
Councillor Burry.
I would like to see 5 minutes for everything. So we get rid of this 2 minutes, 5 minutes, so that we don't have people trying to guess how long they have. Just make it a standard 5 minutes, but empower the chairs to be able to shut the microphone off when people start repeating themselves. So we don't get into the filibuster, which was the reason, I think, originally for the time.
Councillor Bosemuth, I think you had your hand up.
Thank you. Yes, I did. I fully support minimum 5 minutes. And I think in the cases where we've got, I can't remember what they're called, invited presentations, but the ramp examples, I think that should be completely up to the chair, depending on how much material they have and a sense of general how much interest there is. So they should not have any limit. It should be up to the chair.
And I believe, from my understanding, that the chair always has the ability to extend time to the extent that on any of these varieties of delegation, if there's something that needs to be heard, we'll extend it. Councillor Bosenworth, follow up.
Sorry, just to follow up on that. However, when the chair has to make a call to give an exception, then he is subject potentially for being accused of favoring some candidates to the other. So I would like to have, those invited ones not have any limit at all, and the chair determine it at the beginning. Still open to the same potential accusations, but less so.
Thank you. Madam Clerk, you have a comment on that?
Thank you, through you, Mayor Kelley. In regards to invited presentations, the amendment before you doesn't place a time limit on that. So if a member of council or the chair requested an invited presentation, somebody invited to come, there would not be a time limit on that.
Thank you. I did read it, but it was long.
Councillor Mazan.
Thank you. And I'm not sure if we're just focused on the time piece right now, but one of our delegates did bring up a thought about the request for delegation between 7 days and 5 days. I was trying to write that down. Ms. Eplett was bringing up something different there. Is that a separate topic or is this the time to bring that up?
No, yeah. Madam Clerk, go ahead.
Yes.
Thank you. I believe the comment was in regards to when a delegation has to be requested, as opposed and then subsequently when the documents need to be provided. So right now the amendment is written that the request needs to be made 7 business days prior, and the documentation needs to be provided 5 business days prior. So the intention of that was to allow, when people requested, to allow them a couple of days to get their documents together. What I believe our delegate today was noting is that if there was a holiday that fell over 2 business days, that potentially they would have to provide their documents prior to when they actually have to submit their request. What I can assure you is if there was a situation where there was a holiday that fell in there, we would take that into account and always provide those couple of days.
Thank you.
To allow for that.
Councillor Edwards.
I would also like to see it changed that the delegations that want to speak on an application speak at that time, rather than at the start of the meeting, have to sit and wait maybe an hour or 2 for it to come forward. It doesn't save them anything. Plus, we can bring our agenda up at that time rather than trying to look at it. I think it's very confusing to hear 4 or 5 things. An hour later, you're talking about what went on an hour ago when they're making a presentation. It should be when the application comes forward. Thank you.
Councillor Nishikawa.
Thank you. And through you, I completely agree with Alan. I don't like the setup we have now. I just didn't know how to tackle that at this particular meeting. And I'm wondering if there's somehow that we can have a further conversation specifically about when we hear from delegations, because the way that we have it now, I find it confusing to everyone. Or do we just say, scrap this part of it for now and go back to the way we used to do it? I'm not sure the timing. That's all I'm asking is I don't want to like delay moving this forward, but I recognize that it needs some work.
It does need some work. And let me ask the clerk, if I can, please, 2 things. I can't remember what drove the decision to separate delegation from deliberation. That's number 1. And then generally to everybody, does anybody have anything positive or favorable? Is anybody really married to the way we're doing it now, or switching it back to something approximating what it was before? Everybody genuine. I see a lot of heads nodding. So what were we trying to accomplish when we split the 2 apart?
Thank you for the question. In regards to the change that was made to have everybody speak at the beginning, it was made in response to a few comments that we were having to provide an approximate time of when the matter was going to be heard. And I will say that 100% of the time that I have been here when we did that, the time was incorrect. So that was a response to that. The other kind of smaller matters with that was if we have a delegation on the same matter and we have a couple of them, that we'd be potentially making decisions on something that you're going to hear again later on. So this morning was example of that, where we had two presentations on the same matter. So those were kind of the two areas that drove the change. What I can say is there's a little bit of language change now with the potential amendment, in that this would really only affect public comment. So for invited presentations and delegations, those are new matters coming to us. So those could stay at the beginning of the agenda because there's nothing else in the agenda that relates to that. So really, we're just speaking about public comment. And in regards to that, there isn't anything that specifically lays that out in the procedural bylaw. That's more of a little bit more of an administrative function and how we play that out. So there's absolutely room to do a little bit of trial and error with that.
Thank you. And if today's an example, I think we've got a half a dozen delegates sitting here still waiting for us to get to the meat of the matter. The rest are probably watching us on their phones. So I'm not sure that we're saving anybody necessarily. It was worth trying, but I think probably it's no less efficient than no more efficient, than the way we used to. Councillor Bosenworth?
Yeah, a question for staff. What was the original intent of asking for, 7 days or 7 working days and then the material 5? And why are we not, even though we might shorten that up, how many days do we really need from an administrative point of view, and why wouldn't we make that notice as short as possible, but still being able to handle it administratively?
Madam Clerk, go ahead.
Thank you for the question. And if I don't answer it, please let me know. So the idea of the 7 business days for the delegation was to allow staff time to review the request, review the documents, get together a potential resolution should we need one prior to when the agenda is posted, and the agenda is posted 3 days prior. So really, that only gives staff, about 4 days worth of time to get that together. And then with the materials only being submitted 5 days prior, that really only gives us 2 days prior to the agenda being posted. So that was the rationale behind the timelines.
Councillor Kent.
Thank you. I'm trying to figure out how this conversation ties into yesterday's. I thought we had a conversation yesterday and we discussed all these matters and we left it that you were going to come back. So why are we making decisions on those matters right now when those are the same matters we discussed yesterday? I realize we got new input today. That's great, but it just adds to the same pool. I'm just confused.
Go ahead, Madam Clerk.
Thank you, through you. Sorry, thank you, through you. Great question. So yesterday, the intent was to kind of look at some other matters. The topic of time of delegations and presentations and all that came up yesterday, but that kind of leaked into yesterday's discussion. So the purpose of the bylaw that's in front of you was just to address those 3 matters. So the 3 matters being how we run meetings, whether they're electronic or any of that, the working groups and the delegations. And all of that. So we did speak about it a bit yesterday, but that kind of leaked into the conversation. That was to kind of gain some knowledge in how I can best move the bylaw forward based on council and committee's requests.
Any more feedback on these issues? I don't see.
Just seeking clarification then. So I'm hearing that the only change we're looking to make is that public comments should be limited to not more than 5 minutes, where it was previously 2. So I'm hearing that's the only change. Correct. Thank you.
Councillor Kent.
We're not going to shift the schedule the way we just talked about it with, because I thought you just said it was equally as bad to have people sit here from the beginning of the day till their event comes up.
I don't think that's in the bylaw. That's at our discretion. So we can make that change through administrative decision. Councillor Bosenworth.
Forgive me, but just a clarification. So with this, we will still be keeping the 7 and 5? 7 business days and 5 business days. Madam Clerk.
For submission of requests and submission of materials, that is correct.
Thank you.
Thank you. I'm going to read the revised resolution into a microphone, this one. Moved by Councillor Mazan, seconded by Councillor Burry. Be it resolved that the procedural bylaw be further amended as follows. Number one, Schedule A, Section 4.2 be struck out and replaced with public comments shall be limited to not more than 5 minutes. Any comments? All in favor? That's done. Thank you. Thank you very much. That carries. One more piece missing. We just amended the resolution I had read earlier. We have to catch that now. Anybody have any discussion on that as we have it just agreed to amend it? And all in favor? Thank you. That carries as well. Okay, the next one up is a resolution that is really quite long. So I'm going to refer to it. It was in the materials, I believe, right? So everybody's had a chance to see it. It's the Baker matter, moved by Councillor Roberts, seconded by Councillor Edwards. I am not going to read it. Anybody have any questions based on the appendix? Yes, Councillor Nishikawa.
Could you just state publicly what we're doing?
I'm going to ask planning staff, Mr. Pink or whomever, Director Pink or whoever can pick it up. Or I could read it. Yeah. Go ahead, Mr. Soya.
Thank you, Your Worship. For the Baker application, Mr. Fahner was delegated this morning, and he mentioned that after Planning Committee, that he had recommended a bit of a wording change to the proposed wording to provide some additional clarity with regards to future minor additions to existing buildings that could be contemplated within the floodway. And this additional wording is consistent with applicable planning policy, and staff have therefore prepared a resolution that includes this clarifying language if council would like to have it added. And therefore also the consent approval action item was pulled to make sure that the condition of consent, which requires the zoning bylaw amendment to be approved, that contains the same wording, just so it's consistent between the condition of consent requiring the zoning bylaw amendment and then also the minor amendment to make sure that restrictions are in place to restrictions on development within the floodplain of Lake Muskoka. If that's not clear, I'm happy to elaborate. Thank you.
Thank you, Mr. Soya. I have an amendment to read to the resolution we've already read. This is the language that comes from the delegation that came this morning. And I am going to read this one because we haven't seen it before. Moved by Councillor Nishikawa, seconded by Councillor Kent. Consent applications B/16-22/23/ML bracket Baker, roll numbers 6 through 19. No, sorry, wrong. Roll number 6-19-037-50, 6-19-041/042, 043, 044 be amended to remove the last bullet point and replace it with the following. To restrict the construction of new land-based buildings and structures and the enlargement of existing land-based buildings and structures below a static floodline elevation of 226.70 meters above sea level. Any building or structure to be restored, replaced, or reconstructed shall be in the same location and have the equivalent or reduced dimensions. Notwithstanding, minor additions may be permitted, provided the township is satisfied that flood flows will not be negatively affected, and provided that the township is satisfied that safe access appropriate to the nature of the development is provided. All right, any more questions? Any questions on that at all? So we'll vote on this resolution to amend the earlier one. All in favor? And that having been done and carried, we'll vote on the main one as now amended. Any questions? All in favor? Thank you very much. Okay, next up is, we ended this. Done. Yeah, okay. Okay, next one, we've got a communication plan from Kelley, who's going to come up and talk to us about the dark sky bylaw communication plan.
No.
Thank you.
Yeah.
I'm good. Yeah. Thanks. I'm good, thanks. Yeah.
Yeah, have as many as you want, though. For real. Did you tell me?
All right, Mr. Shet, the floor is yours.
Thank you, and good afternoon, Mayor Kelley and members of council. I'm excited to be here to present the communication material for the new dark sky bylaw. As you know, council adopted the updated dark sky bylaw last month, and since then, we've met internally to discuss the best approach to communicate these updates to our community. As you all know, oh, we're already on that slide. As you all know, we've been working on a communication strategy, and this project, the dark sky bylaw, has been seen as a pilot on this new approach to communications. So up here, you'll see past approaches and the new approach. So in the past, campaigns have been done on an ad hoc basis and have included adding information to the website, posting on our social media channels, developing some print materials, online surveys, and hosting public meetings when necessary. So as I mentioned earlier, we are using this updated bylaw as a pilot project to improve how we as a municipality are communicating with the community and how we can improve this process. If this campaign is seen as successful, it may be the standard for educational campaigns moving forward. So next slide, please. So as mentioned, following the approval of the bylaw, we as staff met to develop the collateral that's here, this postcard and poster. And then there's a sticker coming that's not here yet, but it will be coming. And the website as well that you'll see shortly. So late last month, we met with so late last month, we met with a number of stakeholders to collect feedback on the prospective print material. This was done to ensure the information we are sharing is not only valuable to these groups, but also effective and digestible. During that meeting, we did receive a great feedback to improve both the poster and postcard. And now that brings us to today and the presentation of this campaign to you. From here, we will be distributing the print material and begin with the online push of information. And then finally, over the coming weeks and months, as we move through the communication strategy process, we will review and evaluate this campaign to help with the development of a standard for educational campaigns moving forward. Next slide. And so here we are. Before you are the posters and postcards that I mentioned that will be distributed throughout the community. I'm going to work with all of the lake associations and ratepayer groups to have them share this material with their members. We will also have these at all of our facilities and businesses throughout Muskoka Lakes, including marinas, gas stations, grocery stores, the hardware stores, etc. And then later this summer, we plan to go to the farmers markets in both Bala and Port Carling to kind of talk about it and hand out this material. So while we work to have this material distributed far and wide across the municipality, tomorrow we'll also be launching a social media campaign that will include similar information to that included in the poster and postcard. And the goal ultimately of this whole campaign is to be educational on the benefits of dark sky rather than directive on what not to do. So kind of friendly voice across the board. So then the last piece here is the website. Can you pull it up? And that was kind of the last piece of the puzzle. So we're online and print. You just scroll down a bit. So the whole goal with this website is just for it to be digestible, easy to read. Hopefully the information that people are looking for has similar information to that that's on the poster. And it's just a similar model to the water levels website that I had presented in the spring earlier this year. So yeah, if you have any questions, I am available to answer them.
Thank you very much. Anybody with any questions? Councillor Bosenworth.
One of the key attributes we have in our new dark sky bylaw is the 11 o'clock curfew. How do we feature that in the materials that we've developed?
Thank you. And through you. So that isn't exactly on the poster and postcard. That being said, all of those kind of key points are going to be seen in our online social media campaign.
Any other question? Councillor Mazan.
It's not a question, it's a comment. Is that okay?
Sure.
I can't help myself. Is that okay?
Go ahead.
This is fantastic. As an introduction and as a start, as a pilot for somebody who's been sitting around and we've been talking about this type of thing. We just confirmed our bylaw, what was it, last month or 2 months ago? And to know that it's already following up with something creative, innovative, friendly. I like that word, user friendly. This way we'll have all sorts of learnings, I'm sure, from this, but I just wanted to congratulate you. Honestly, I just can't help myself. Thank you for giving me that chance.
You're welcome. Councillor Kent.
Yes, the materials look great. Quick question, does the website reference tie-in so you can get the details of the bylaw if you want it?
Yeah, so it's linked directly to the bylaw.
Well, no, there are a lot of details. It's not all big pictures.
Councillor Bosenworth.
I would like to echo Councillor Mazan, although we're not supposed to be repeating things. This is very silent. This is very exciting, and the fact that you took this proactively from the very minute we thought about doing this is just fantastic. And so we hit the road running. It is just and I keep saying we need to change the tone. This is how you change the tone.
Thank you. Any other questions? Yeah, Councillor Burry has a question.
So I do have a question. I love the poster. Where do you think you're going to put it?
Everywhere, anywhere it can go. We plan to put it at all of our
library,
facilities.
museums, potentially the liquor store. Think people go there? Marinas. I love the poster.
Anywhere light bulbs are sold.
The question of light bulbs is, do you make the light bulbs, you can only go to 2700 Kelvin sold in the township?
Okay, next, sorry, Councillor Edwards, sorry, Roberts, you've got your hand up.
Thank you, Chair, and through you, yes, I'll just use the word excellent. And then I would like to have one question. Can you explain for me the idea, what is the social media campaign you'll be doing?
Sorry, go ahead.
Thank you, through you. Yeah, so Councillor Roberts, after this meeting, I'll send you these materials electronically so that you can review them yourself. But there are some key points on the poster and the postcard, and I'm going to break those down into individual posts. And then from there, just kind of breaking down the points like Councillor Bosenworth said about the 11 o'clock p.m. curfew, all of those kind of key things that we need to communicate That'll be what the social media campaign is based on.
Thank you very much. Anyone?
What would be the vehicle then of communication?
Go ahead, Kelley.
Through you, I'm just confused about your question, but are you referring to Facebook, Twitter, all of our social media channels, or something else?
Radio, TV. I'm just thinking off the.
Yeah, so we're going to get it out everywhere we can, essentially.
Okay, thank you very much. Are there any other questions? Councillor Edwards.
Just a question. Are you putting the large ones in all the community centers and small ones there so that people can take them home? Great, thank you.
Go ahead, Colleen.
Through you, yes. We're going to put them in all of our facilities, and there'll be stacks of the postcards as well. Anywhere that we can get them, we're going to put them.
Okay, can we, any more questions, any more feedback? Councillor Bosenworth, and then this.
No, just a suggestion that they are at the farmer to market, and we might have volunteers from this council to attend.
Anybody else with a question? None. Thank you very much for this. We appreciate it, and very well done. On that note, I am recusing myself from the next discussion. I'll yield the chair to the deputy mayor, and I will be back when you're done with this one.
Right. We all have to join the line.
Thank you. And what item was this? Item server. Okay, so we are currently on item 7B, council. And I'm going to, similar to what we've done in the past meeting, I will read the resolution and then open up the conversation at that point. So moved by Councillor Edwards, seconded by Councillor Nishikawa. Be it resolved that council approve the waiving of fees for the Windermere Lions Club in the amount of $1,100 plus tax for the use of the Windermere docks for 8 weeks, 8 weekly bookings during the 2023 summer season. So at this point, I will ask, I think Councillor Edwards, if you would like to lead off the discussion. Thank you.
Yes, first of all, looking at the resolution, the amount is $1,100. It should be $1,000. It was $125 a week. Now, last year, the Windermere Lions Club had their barbecue set up by the freight shed in Windermere, and they sold hot dogs and hamburgers and that. They also made an agreement with the arena who sells French fries that they would take the money from them. They would give them a ticket. They would go over and get their French fries there. So it was an economical boost. And of course, you go over to get your French fries and the kids see there's ice cream and that there, so they want one afterwards. They had it all last year for free. This year, when they wanted it for 10 weeks, they were told it would be $125. It's half the normal fee. And they would have to pay $1,250 plus HST, which brought it up over $1,400. They only made hardly $2,500 last year. It's a service group, and that they didn't have it at the wharf for the last 2 weeks. What they did is they asked the Windermere House, and they let them use a corner of their property for it. So they were able to have it because they had purchased all their hamburgers for the year, which I know because I was storing them in the church freezer for them. They bought 500 hamburgers. So it's just a case of now kids have to go from the waterfront and cross a road to get there. It's a safety issue as well. It's a service group, and I think they should have it for free like they did last year. It's a community service. And again, any profits they make goes back to the community. If there's any questions, I can answer them.
Okay, thank you. Councillor Nishikawa.
Thank you. I mostly want to suggest or ask council to please move this forward. I will be asking when we further discuss the bylaw about service groups and whatever, that some of those groups, so for instance, this Lions Club, we've got a few different Lions Clubs, actually hand in the report. I've seen the reports. I see the amount of money and the community service that these groups do. Again, a service that we don't provide as a municipality. Quite frankly, we're not really in the business of community service, but yet these social groups are. They are filling our void, I guess. And I don't want anybody to focus on a number. Again, in the overall budget and everything else, it's a very, very small amount out of our community budget, if I was to say that about community centers and et cetera. So I hope that everyone agrees to move this forward, but going forward, I would also ask that we ask these clubs to actually show us, for instance, over the last 5 years, what have you been doing? I happen to get to know and I see what other groups are doing, but perhaps other councillors aren't aware and why I support these initiatives. Thank you.
Thank you. Okay, council, are there any other questions, comments? Councillor Bosemarth?
I'm curious how it was that they were able to use these facilities last year without a charge and this year with a charge. Like, seems to me a precedent has been set. And if they didn't pay last year, why should they pay for this year?
Okay, thank you. I see Director Becking is on the call, so I will ask him to respond. Thank you.
Thank you, Madam Chair. Under the current policy, this group is eligible for a 50% reduction from the full rate. All groups are at liberty to appear as a delegation before council to request additional dispensation. But staff are strictly following the policy. If council wishes to provide further relief from the policy, then that's council's discretion. That's not staff's discretion. This group appeared as a delegation. Council chose to waive the fees that time for that amount. It's a one-time only. There was nothing in the resolution. We went back and checked it. There was nothing in the resolution that it said it should be for all subsequent years. So staff are sticking with the strict letter of the policy.
Yeah, thank you. Councillor, are there any other questions or comments? Councillor Bosemarth?
Just to be clear, I think earlier today we had a discussion that said we were going to ask staff to come back with a proposal on this. So why don't we just apply that here or give them dispensation as we did last year?
So I think that's two separate things that have been brought forward. The one that we were talking about earlier today is a future forward analysis of our entire approach, I would say, to this. So it's the policy we would be looking at. Today, there's a specific request in front of us, and it's meaningful because it's right now and in front of us. So, okay. I was about to call for the vote. So if you can let me. Is that okay? Thank you. I see no other questions or comments. So I have read the question. All those in favor? Thank you. That is carried. You're welcome. Oh, thank you. Yes.
I just
Councillor.
wondered, since we've passed that, if the Director Becking or somebody from the Public Works could let the Lions know so they can move in there on Friday again.
Okay, Director Becking, I'm not sure if you're still on the call, but the request was simply just if somebody from your group could actually follow up with the Lions Club to know what was passed today so they can make plans for this weekend, this Friday. I guess
We'll
it's
take
this
care of
Friday.
it, Madam Chair.
Thank you very much.
Thank you, Mr. Becking.
Thank you.
Okay, thank you very much. I'm back. Next one we've got is a report from Director Becking on bridge load posting bylaw.
Thank you, Your Worship. Council has the authority to restrict the weight of vehicles passing over our bridges in order to protect them and the public safety. The Dark Bay Road culvert is showing some signs of distress, and out of an abundance of caution, staff are recommending that the structure be posted. We are also recommending that council undertake some administrative matters to remove the restrictions on 2 other structures that have been reconstructed and no longer require any restrictions.
Thank you. Okay, anyone with any questions for Director Becking? And I'm going to read a resolution moved by Councillor Edwards, seconded by Councillor Kent. Be it resolved that a bylaw be presented and given 3 readings in order to regulate the weight of vehicles passing over the Dark Bay Road culvert, RDS-BRDG-C001, and that bylaws 2019-083 Bala Falls Bridge, bracket RDS-BRDG-B001, and bylaw 2019-085 Milford Bay Road Bridge, bracket RDS-BRDG-B004, regulating the weight of vehicles passing over each respective bridge, be repealed. Any questions? All in favor? That carries. Thank you. How about I put this on? Director Becking, would you tell us about the reconstruction of Baycliff Park boat ramp, please?
Thank you, Your Worship. Staff tendered for the works. We only received 1 bid, and the bid was extremely high. Staff are of the view that it doesn't represent good value for money, and the staff recommendation is to not award the contract. We will sit down with the consulting engineer who was responsible for the project and revisit the design to see if there are any improvements that can be made to it. And we will bring it forward as part of the 2024 budget package with council's permission.
Thank you very much. Does anybody have any questions on this matter? I have a resolution moved by Councillor Mazan, seconded by Councillor McIntyre. Be it resolved that council not award contract T-2023-45 to Areens Construction Ltd at the price of $248,803, and that staff be directed to reevaluate the project scope and include a revised project cost for inclusion in the 2024 capital budget. Any questions? All in favor? Thank you very much. Okay, next up again from Director Becking, backup power supply for Walker's Point Fire Hall. Please, sir.
Thank you, Your Worship. Staff recommendation is that it be awarded to the lowest compliant bidder, Quimby Electric Inc., in the amount of $69,000.
Thank you. Any questions for Director Becking? Councillor Bosenworth.
What was the financial value of the McMorran bid?
Your Worship, that's not a relevant matter because the bid was disqualified. It wasn't compliant.
Thank you very much. Any other questions? I'll read the resolution moved by Councillor Nishikawa, seconded by Councillor Roberts, that council award contract T-2023-49 to Quimby Electric Inc. for the price of $69,000, taxes excluded, and that the Director of Public Works be authorized to execute the necessary documents to proceed with the purchase. Any questions? All in favor? That carries. Thank you. All right, next on, I believe, is Our clerk, Madam Clerk, are you doing a presentation from your chair?
I will keep it brief. The report is there in front of you. It's just appointing counselors to the rest of the hall boards. Just a reminder that the committee, or that the community members who are being appointed to the hall board were circulated in a closed session memo. If you need to discuss any of them, we should postpone this matter and wait until after closed session. If everyone is happy and doesn't need to discuss, then we can go ahead and pass this and that memo becomes public. Thank you.
Thank you for that. So let's start with any questions that anyone might have about the community member appointments that have been covered in our closed materials. I see none. Anybody have any other questions about the matters that are in front of us? Seeing none, I will read this. Moved by Councillor Zabit, seconded by Councillor Bosenworth. Be it resolved that council members be appointed to community center hall boards as detailed in this report, LS-2023-23, and that citizen members be appointed to community center hall boards as detailed in confidential memo LS-2023-24, and that confidential memo LS-2023-24 be hereby made public. Any questions? All in favor? That carries. Thank you. Next up, sir, Mr. Director Donaldson, Director of Financial Services, talk about IT servers, please.
Thank you, Your Worship, and good afternoon, Council. So the item, the report before you is regarding an item that was approved in the 2023 capital budget. As noted in the report, time being of the essence, the vendor was directed to proceed, and this report is being brought forward to Council to confirm approval with acquiring this needed infrastructure, computer hardware. So I'll take any questions.
Thank you, Director Donaldson. Does anyone have any questions about this? And I'll read the resolution. Moved by Councillor Roberts, seconded by Councillor Burry, that the purchase of a Lenovo Think System IT server at a price of $142,558 plus HST be approved, and that the 2023 capital budget be amended to transfer $20,000 from project 99115, computer related, to project 23001, data center servers, and that the Director of Financial Services be authorized to execute all documents necessary to proceed with the purchase. Anybody have a question on the resolution? All in favor? Thank you. That carries. Next, report from our Chief Municipal Bylaw Enforcement Officer. Is he joining us in person? He's coming up. Oh, there he is. Sorry, couldn't see you there, Mr. Kennedy. How are you? Welcome.
Thank you.
The floor is yours.
Through the chair, I will keep this relatively short. These, I think it's about 13 or 14 different bylaws, are the amendments that are needed in order to allow for the bylaws that were deemed as designated bylaws under the AMPS bylaw to start actually issuing monetary penalties to offenders if they do contravene the bylaws. So that is in a sense what these 13 or 14 bylaws are for. And that is essentially the next step in being able to implement the AMPS program within the municipality. Next step, and which should happen relatively soon, is the hiring of our administrative assistant. And from that point on, we will be able to start issuing monetary penalties under the AMPS bylaw. Thank you.
Thank you, Mr. Kennedy. Does anyone have any comments? Mr. Kennedy? Councillor Bosenworth.
Just a question. I think I forget if it's called the adjudicator, the outside person. Has that already been selected?
Mr. Kennedy?
Yeah, through the chair, I believe he would be talking about the hearing officer. No, that has not been selected as of yet. I've put some feelers out with a couple different law firms in the area to gather some interest, and it seems like there's quite a bit of interest for that type of position. So I'm confident that we can hire someone in the near future.
Thank you, sir. Any other questions? And this is for information only. I don't believe there's a resolution. Well, thank you for your time and your input. We appreciate it. pass through the bylaws when we get to that stage. All right, what do we got? What's next? What I got here is a shore road allowance. In the order of what I've got. All right. Under bylaws, general and other planning bylaws, unless you have something for me, no. Bylaw number 2023, original shore road allowance, May Pecos. Does somebody have a report on this? And there's no report on it, then I will read it. Moved by Councillor McIntyre, seconded by Councillor Kent. Be it resolved that the original shore road allowance on Skeleton Lake, lying in front of concession 13, lot 12, Watt, designated as part 2 on plan 35R-27134-May/Pecos, roll 2-21-046 be declared as surplus land, and that the clerk is hereby instructed to dispose of the said property pursuant to sections 8, 9, and 11 of the Municipal Act 2001, and that bylaw 2023-068 to stop up, close, and convey that portion of original shore road allowance designated as part 2 on 35R-27134 be given 3 readings and passed. Anybody have any questions? All in favor? Thank you. Okay, moved by Councillor Mazan, unless we have nobody speaking on this. Councillor Mazan, seconded by Councillor Bosenworth. Be it resolved that bylaw 2023-073, being a bylaw for the purpose of closing that part of Sagamo Boulevard, registered Plan 32 of the Geographic Township of Medora, now in the Township of Muskoka Lakes in the District Municipality of Muskoka, designated as Part 1 on Plan 35R-26963, be read a first, second, and third time and finally passed. Any comments? Any questions? All in favor? Thank you. I'm gonna. Okay. The next one, moved by Councillor Burry, seconded by Councillor McIntyre. Be it resolved that bylaw 2023-074, being a bylaw for the purpose of acquiring part of lot 35, concession 12, Geographic Township of Medora, now in the Township of Muskoka Lakes, in the District Municipality of Muskoka, designated as Part 2 on Plan 35R-26963, in exchange for the transfer from the Corporation of the Township of Muskoka Lakes of Part 1 on Plan 35R-26963 to the registered owners of the abutting lands described as PIN parcel registers 48142-0265 and 48142-0452 and to establish said Part 2 on Plan 35R-26963 as part of the municipal highway system, be read a first, second, and third time and finally passed. Any questions? All in favor? All right, before we move on to this next one, let me have a quick conversation. And next one is moved by Councillor Edwards, seconded by Councillor Nishikawa. Be it resolved that bylaw 2023-089, as amended, being a bylaw to govern the proceedings of council and committee meetings for the Corporation of the Township of Muskoka Lakes, be read a first, second, and third time and finally passed. All in favor? That carries. Thank you. Thank you. And just so that everybody knows, the next 12 or 13 bylaws have been consolidated into one motion. So I don't have to read this 13 times and you don't have to listen to it 13 times. And then we can move into the ones of more substance. Moved by Councillor Kent, seconded by Councillor Roberts. Be it resolved that bylaws 2023-077, 2023-078, 2023-079, 2023-080, 2023-081, 2023-082, 2023-083, 2023-084, 2023-085, 2023-086, 2023-087, and 2023-088 to implement the administrative monetary penalty system be read a first, second, and third time and finally passed. All in favor? Thank you. All right. So. All right. 17. All right, there's a couple of more of these more administrative ones, and we get into the zoning bylaws and we'll deal with the stuff that I think there are people waiting to hear. The first one is moved by Councillor Kent, seconded by Councillor Bosenworth. Be it resolved that bylaw 2023-076, being a bylaw to deem lots 5 and 6 on Plan 34 in the former township of Medora, now in the township of Muskoka Lakes, District Municipality of Muskoka, being lots on a plan of subdivision are hereby deemed not to be lots on a plan of subdivision for the purpose of section 50 sub 3 of the Planning Act, common 1990 as amended. Sui and Tong, roll number 4-11-019, be read a first, second, and third time and finally passed. Questions? All in favor? Thank you. All right, the next one is the appointment to represent our interests at the Muskoka Lakes Chamber of Commerce, moved by Councillor Bosenworth, seconded by Councillor Zavitz. Be it resolved that bylaw 2023-090, being a bylaw to appoint a council member to the Muskoka Lakes Chamber of Commerce, be read a first, second, and third time and finally passed. Sorry, are these votes or questions? Anyone with a question?
It's a comment then, so I'll wait. But
Oh, no, go ahead. Comment's good. Go ahead.
Thank you. While I don't have an issue at all about who is being recommended, I do have a concern about us becoming voting members. And I've been a director of that chamber, you know, before it became the Muskoka Lakes Chamber and things. So I have a pretty good understanding, and also been that contact person or that counselor that was on, you know, essentially my role was to report back what I learned attending the meetings. The voting part, I think, is a very dangerous direction that we're going in. And in fact, you yourself had conflicts. You felt a conflict. I don't believe that we need to have a vote around the council table. I think our job is to report back of what we've learned, but not as a voting member is my concern.
Let me respond to that quickly, because I couldn't agree more. And so the question is, what does the nature of this appointment take, or you know, what shape does it take? The problem is we don't know until we ask the chamber whether they have, for instance, the ability to appoint a non-voting member to the board. I just don't know what we're going to ask the chamber how best to incorporate the appointed person into, so that they aren't in a conflict constantly. Okay. Councillor Edwards.
Yeah, if they're not a voting member, I don't think they would have to declare a conflict. If they were a voting member, they may have to declare a conflict. So I think that should be removed. We should point that out to the chamber as well, and they will probably agree.
Our CAO has asked to speak on that.
Thanks, Your Worship. So I would also remind council that in general committee, a little while back, committee directed that we review the MOU with the chamber, and that was certainly one of the provisions that you had interest in amending. So that as we go forward and come back with an amended MOU, that will be taken care of. Thank you.
Councillor Nishikawa.
sorry, procedurally, should we be moving this forward today? Because the word vote is in that bylaw. So that's why I'm just kind of.
I don't see the word vote. Oh, in the bylaw, sorry. Yeah, okay, so what we're going to propose, good catch, thank you, is to just strike out the voting member and replace it with non-voting members.
That's the common term.
Was it? All right, observer. And you'll make that change. And we'll make that amendment. I've already read the resolution.
So you can be.
Okay, so we'll make a quick amendment, read that to what I've already read. All right, thank you. And through you, or through you, in order to accomplish that, we've made a quick amendment here. I'm just going to read it. Steer it towards me. Oh, I'm seeing this flash. Moved by Councillor Bosenworth, seconded by Councillor Zavitz. Be it resolved that bylaw 2023-090 be amended as follows. Remove quote voting member and replace with observer. All right, so we'll vote on the amendment first. Any questions on that one? All in favor? So that one carries. And now, having amended the original resolution that I read, all in favor on that one? That carries. Thank you very much. Sign it when you get it back. All right. Okay, the next one that I have is bylaw 2021. Here we go, is a bylaw relating to the official plan amendment for Donaldson and Sifft. I will read the resolution. We can have the discussion. Moved by Councillor Roberts. Seconded by Councillor Nishikawa. Be it resolved that bylaw 2021-101 being a bylaw of the Township of Muskoka Lakes to adopt amendment number 57 to the official plan of the Township of Muskoka Lakes be read a first, second, and third time and finally passed. And I see Mr. Soya, you have joined us. You have some input on this, please. You're on mute.
Can you hear me now?
Yes, sir.
Sorry about that. I just wanted to point out that this bylaw is related to the Donaldson and Sifft application, that the zoning bylaw is further down in the agenda, and committee may wish to consider both the official plan amendment and the zoning bylaw amendment together. Thank you.
Thank you.
You can't have two models on at the same time. They have to do this.
Yeah, could you just give me some direction on this now that I've read the one?
If I can just ask clarification from our planning staff, as we cannot have two matters on the table at the same time, so we have a resolution on the floor right now. So I think our mayor is looking for some direction on how to proceed with the matter that's on the floor at this time, the OPA amendment.
Go ahead, Mr. Sharp.
Thank you, Your Worship, and through you to the clerk. I believe the consent applications were included in the consent agenda and have already actually been approved with respect to the official plan amendment and the zoning bylaw amendment aspects. I think all Mr. Soya was indicating is that if council is wishing to debate those items, it may make sense to have that debate and then read the resolutions, but I'll leave it in your more than capable and experienced hands. Thank you.
Okay, thank you very much. I am going to ask on this one that I have read, whether there's any questions on this matter or debate. I guess ultimately, Councilor Nishikawa.
Comments. And
Yeah.
essentially, a number of times, Director Pink pointed out that everything met the requirements. And essentially, whether I like it or not, it's met the requirements. And so I need to move forward with because otherwise we would be risking issues with our municipality that we may or may not win. That's all.
Councilor Kent.
I agree with you, Councilor Nishikawa, except for the fact that Councilor Bosworth made a comment about the, subject to our being comfortable. What was the language that you had? Because that was, in my opinion, where I felt that we were wrong. I don't think that, I just want Rob to repeat it, or Councilor Bosworth to repeat it.
It's, I think the.
Yeah, are you going to respond? Is that because you were called on it? Okay, go ahead.
It's getting a bit late. My point was that the bylaw requires that we have to have a proof of parking on the mainland to the satisfaction of council. And I was just calling it of the township. Thank you. And I was just calling to question whether some of the information presented today caused us enough doubt to not meet that criteria.
Thank you. Councilor Kent.
That comment, I feel that I still have doubt in my mind, given I know and understand the situation at these island marinas, that there is no, I'd like to see the parking study and the fire study before I said that parking was adequate. I'm not comfortable, and I don't think that without bumping existing clients, they're being 100% honest. It's going to be very difficult.
Thank you, Councilor Nishikawa.
Sorry, we need to pay attention to the application. What the information that was brought forward is actually not even about this property. A lot of the concerns that were brought forward about the operation of a marina, other marinas were brought up, that type of thing. The operational model was not part of the question that's being asked today.
Well,
I don't know how else to make this very clear, that we need to direct ourselves to the application and the things that are brought forward, that in fact, when staff are saying that they have everything in place, they have all of the requirements that we as council requested, we need to move it forward. That's all I'm just saying.
Thank you. I see Director Pink is on the screen, and I think he's going to shed some light for us, please.
Thank you, Worship. I just wanted to
clarify a little bit, maybe perhaps put it in a little different perspective than I was previously stating. But again, I would reiterate that what is before council are applications for consent, an official plan and zoning amendment on an island property, not an application for parking on a marina property. But I heard a number of the delegates speak to, that perhaps the spaces don't exist because other users may lose their space, or the marina property would be deficient because those spaces are slated for or needed for retail in accordance with our current bylaw. That is not the test in the official plan. The official plan test is that that docking and parking be secured, and we have a lease, an owner who's entered into an obligation to provide those spaces and parking. The test is not that other users may unfortunately lose out on their spaces, or that the test is not that a retail establishment that's legally deficient in parking may be more legally deficient in parking. Those aren't the tests. The test is they've secured and have an obligation that marina has committed to providing those parking spaces. So I think that's really what's before you again is the application for consent. I wanted to provide that clarity and also advise council that earlier in the meeting, the consents were approved, at which time the action items were. So what's left is the official plan amendment and zoning bylaw. So just some clarity there as well, available for any questions.
Thanks, Director Pink. Anyone have any questions while he's gone? Councillor Bosenworth.
One more comment. Earlier today, Mr. Pink pointed out that even in the extreme case where the terms and conditions of this contract were not allowed to be met, the property owners still have an obligation to ensure that they have parking. And that was a sort of a top level confirmation. So my concern has been removed.
Thank you. Anybody with any other questions, comments, anything to add to the discussion? Otherwise, Councillor Kent.
My only observation with this conversation is we're relying on, my comfort that Mortimer's Point and Mortimer's Marina are telling us they can do something when they may not be able to do something. It's very clear that it's not likely that they're going to be able to deliver on this, even if they've signed a contract. That's what makes me nervous. I'm not accusing them of lying, but I question I don't feel that it's really there. And I mean, I know the situation and I've seen the marina, and we're just going to load up a problem that's going to get worse and worse.
Okay, we'll just.
So yes, we have a contract, but the contract may not be true. That's all.
Councillor McIntyre.
My concern is that we have a director of planning who is saying that in his vast experience, this meets the terms of the Planning Act. And if we go against that advice, it could cost the municipality a whole bunch of money, because these people are likely to take it to court and they're likely to win because Mr. Pink knows the law better than we do. That's my.
Thank you for that. Anyone with anything else? Councillor Edwards.
Thank you. The application was for consent, and that I can give that. The parking, we've asked for letters before. Now we have a signed contract, although I don't like it. It's better than we've ever had before. And I think what we should be doing is looking at our severance policy for islands and maybe tightening it up in the future. But at this point, there's nothing that we can do. And I would have to support it, even if I have to hold my nose. Thank you.
One last pass with questions or comments, debate. Seeing none, I'll call the question. All in favor? And opposed? Sorry, opposed is yes. Okay. Thank you. So that does carry. Thank you very much. And just read it.
We do have minor amendment.
Oh, okay, so we'll just read it first and second. Okay, next up, we have a resolution to amend the comprehensive zoning bylaw for this same property, moved by Councillor Mazan, seconded by Councillor Zavitz. Be it resolved that bylaw 2021-047 to amend comprehensive zoning bylaw 2014-14, Donaldson and Sifft, roll number 6-27-011, be read a first and second time. There are minor amendments, so first and second time. Anybody with questions? All in favor? And anyone opposed? That carries. All right, next one up is moved by Councillor Edwards, seconded by Councillor Burry. Be it resolved, the Township Council amend bylaw 2021-047, bracket Donaldson and Sifft, roll number 6-27-011. And these amendments are minor in nature and do not require further public circulation and are hereby approved prior to third reading. These amendments shall consist of Schedule 2 being replaced with a revised site plan showing a revised boundary of the proposed environmental EP1 zone. I assume that's 2. And next, section 2.1 III be amended to only permit the existing 3 land-based sleeping cabins on retained lot number 5/resultant lot number 6 in application B36/21/ML until such time as an application is filed for a building permit for redevelopment of the existing dwelling or sleeping cabin, and thereafter only permit a single sleeping cabin or 2 sleeping cabins with a combined maximum floor area of 661 square feet. Any questions? All in favor? Thank you. That carries. All right, we got another one, and this is now that we've done those 2 amendments, moved by Councillor McIntyre, seconded by Councillor Nishikawa. Be it resolved that bylaw 2021-047, Donaldson and Sifft, roll number 6-27-011, be read a third time and finally passed. Any questions? All in favor? And that carries. Yep. Okay. What are we doing here? Oh, there's a second time in a minor amendment. Okay, that's good. All right, this is the Valenti matter. Moved by Councillor Bosenworth, seconded by Councillor Kent. Be it resolved that bylaw 2022-189 to amend comprehensive zoning bylaw 2014-14, bracket Valenti, roll number 4-25-032-24, be read a first and second time. Any questions? All in favor? That carries. All right. Moved by Councillor Zavitz, seconded by Councillor Roberts. Be it resolved, the Township Council amend bylaw 2022-189, bracket Valenti, roll number 4-25-032-24. And this amendment is minor in nature and does not require further public circulation and is hereby approved prior to third reading. The amendment shall consist of 164 front yard setback being required for land-based buildings and structures and any leaching bed distribution pipe on the severed lot. Any questions? All in favor? All right, this is Valenti as well, moved by Councillor Burry. Seconded by Councillor Edwards. Be it resolved, the bylaw 2022-189, Valenti, roll number 4-25-032-24, be read a third time and finally passed. All in favor? That's good. Thank you. This is doing this same thing. All right, this is Baker matter, moved by Councillor Mazan, seconded by Councillor McIntyre. Be it resolved that bylaw 2023-040 to amend comprehensive zoning bylaw 2014-14, Baker, roll number 6-19-041, 42, 43, and 44, be read a first and second time. All in favor? Okay. What do we got here? Baker again, moved by Councillor Roberts. Seconded by Councillor Burry. Consent applications B/16-22/23/ML. Baker, roll numbers 6-19-037-50, 6-19-041/042/043/044 be amended to remove the last bullet point and replace it with the following. To restrict the construction of new land-based buildings and structures and the enlargement of existing land-based building and structures below a static flood line elevation of 226.7 meters above sea level. Any building or structure to be restored, replaced, or reconstructed shall be in the same location and shall have the same, have the equivalent or reduced dimensions. Notwithstanding, minor additions may be permitted, provided the township is satisfied that flood flows will not be negatively affected, and provided the township is satisfied that safe access appropriate to the nature of the development is provided. All in favor? Right, last one on Baker, moved by Councillor Edwards, seconded by Councillor Nishikawa. Be it resolved that bylaw 2023-040 bracket Baker, roll number 6-19-041, 42, 43, 44, be read a third time and finally passed. All in favor? Thank you. It carries. All right, we have a staff introduction. The next one is a Sifft matter, and I've been noted that there's someone from planning or someone wants to speak to it. I don't know who it is. There we go, Mr. Soya. Welcome.
Thank you, Your Worship. For this one, I just wanted to point out that Planning Committee had asked for an existing dock to be removed prior to third reading of the bylaw, and that the applicant has provided a photograph and confirmed that that dock has been removed. That is all I wanted to point out. Thank you.
Thank you. Any questions for Mr. Soya before he leaves? Thanks very much, Sam. Appreciate it. Oh, sorry. Hang on. Councillor Edwards.
If I've got this right, on page 285, I thought it was a single-story boathouse on Sifft there. And yet I'm reading it on page 285, the first and second story width of a two-story boathouse. Was that changed? That's on page 285, bullet 2.
Mr. Soya, can you respond to that, please? Yes, thank you, Your Worship, through you. Just to clarify, the Planning Committee recommended approval subject to minor amendments, and the minor amendments permit only a one-story. Those minor amendments are required to only permit a one-story boathouse with a width of 34 feet and a cumulative dock width of 64 feet, and to replace Schedule 2 with the revised site plan. Thank you.
Okay, thank you.
So that's going to come up in the amendment in a moment. Okay. Thanks, Mr. Oh, Councilor Nishikawa.
I'm sorry, I'm not sure if my question would be to Sam through you. You know, a gentleman spoke, I believe, on this particular application. I was a little concerned that we didn't have a bit of an introduction of what he was talking about. But I have some concerns that he raised, and I don't know if staff have more details on that. So he was talking about a barge being parked there and some other things. I do have that concern that this may become a contractor's location. I'm sorry. Well, I'm just saying. So I want to be respectful that the speaker brought some issues forward, and I wondered if staff had some additional information to bring.
Mr. Soya, can you help us with that, please?
Through Your Worship, the speaker this morning or earlier this afternoon, the delegate on that delegated on that matter, he had concerns with the size of the proposed dock, And I believe he was mentioning the number of boats that could potentially be docked at on a dock that size as is proposed. And I believe he also raised a concern with the previous dock, which has now, which we've now received confirmation has been removed as intended. And there was a barge parked at that dock, at this previously existing dock, prior to its removal. And now that the dock has been removed, the barge is no longer in that location, and there is no dock currently on the property. Hopefully that clarifies. Thank you.
Thanks for that, Mr. Soya. Mr. Edwards, or Councillor Edwards, you have a question.
Yes, to Mr. Soya. It was an OMB hearing that came up with the dock and that. Why are we going larger than that?
Mr. Soya.
Through you, your worship. So this, as committee may or council may recall, this proposal initially involved a two-story boathouse, and the applicant then came back to planning committee and proposed to reduce the proposal to a one-story boathouse. There was a prior restriction on dock width that was imposed through that previous bylaw. And the new proposal, though, involved the applicant requested a dock with a greater width, and an exemption was added to the proposal to permit that additional width, and was considered by planning committee in June. And committee then considered that as well, and recommended approval of that exemption for that the dock that is now proposed. Hopefully that clarifies. Thank you.
Thanks. Thank you, Mr. Soya. Any other questions? Any comments? Have I read this? Sorry, Councilor Nishikawa.
I'm sorry. I just do want to clarify, because I had that same concern that Alan had, because it's very rare that we would go against an OMB decision. And again, I never did kind of figure out how much more we were allowing other than over the OMB decision, because I found it difficult to track all the information.
Director Pink, welcome.
Thank you, Your Worship. I just thought I would clarify because it was slightly before my time, but I do vaguely recall the application previously, the historical zoning amendment. And I wouldn't say we're going against necessarily the OMB decision, although council can pass further bylaws. But just to clarify my recollection of the file, the width restriction was placed entirely because of fish habitat concerns of previous consultants over, I believe, 20 years ago. They didn't necessarily identify a specific amount. I believe the previous consultants just suggested that the width be reduced to some extent. We now have a consultant who's reviewed the current conditions of the site and has indicated that there are no concerns with the proposed width. Keep in mind the width is still fully compliant with what the current zoning bylaw would allow, save for the historical zoning amendment, which again was imposed entirely for fish habitat. Those concerns have been addressed. This consultant put their mind to the actual width itself, a specific number, and is fine with the 64 feet proposed. Hence, staff does not have a qualified professional's opinion that says the width should be reduced any further, and hence our recommendation. I hope that helps clarify the concerns that I believe were raised by the neighboring property owner.
Thank you, Director Pink. Don't see any other questions, so I will call the question. All in favor? That carries. Thank you. Okay, next up is an amendment to that last one. Moved by Councillor Roberts, seconded by Councillor Edwards. Be it resolved that Township Council amend bylaw 2022-159 brackets Sifft, roll number 4-5-025-03. And these amendments are minor in nature and do not require further public circulation and are hereby approved prior to third reading. These amendments shall consist of the exemption to permit a two-story boathouse with first and second story widths of 34 feet being replaced with an exemption to permit a one-story boathouse with a width of 34 feet in the location and extent shown on the revised site plan. An exemption being added to permit a cumulative dock width of 64 feet in the location site plan, and the site plan forming Schedule 2 being replaced with the revised plan. Any more questions on this? All in favor? Thank you. That carries. Then, okay, to close that one off, moved by Councillor Kent, seconded by Councillor Bosenworth, be it resolved that bylaw 2022-159, Sifft, roll number 4-5-025-03, be read a third time and finally passed. All in favor? That carries. Thank you. Okay, so next one up is Aberbush. And I'm told somebody from planning wants to speak with this issue, and somebody's coming on right there. Who do we have? Oh, Caitlin. Welcome, Caitlin.
Thank you, Your Worship.
What do you want to tell us?
So I just want to give a quick overview of where we're at with this application. So as you likely remember, in June, Planning Committee heard zoning bylaw amendment applications at BA 57/22, bylaw 2022-192 in the name of Aberbuck. The subject property is known municipally as 1683 Breckenridge Road. The bylaw will provide several exemptions related to as-built structures on the subject property. In June, Planning Committee did recommend approval of the application subject to third reading being withheld. And there was two items that had to be addressed. The first is that the recommendations of the water quality impact assessment are, including all the required restoration and renaturalization works, are completed to the satisfaction of the township. Committee also recommended a review and consideration by a qualified professional of the reduction in stone patio size and other hardscape works within the shoreline buffer as a component of the renaturalization plan. Since the June meeting, staff has been corresponding with Hutchinson Environmental, who completed the peer review, for comments regarding the removal of stone patio area and other hardscape works. The scope of the review is still being finalized, and staff don't have any further updates to provide at this time. As a result of the ongoing review, staff does not recommend third reading be given at this time. I have no other comments, but I'm happy to assist with any questions. Thank you.
Thank you, Ms. Walker. Anyone with any questions for Ms. Walker? No? I want to apologize for messing up Aberbuck. I could have pronounced that better. It's been a long day. Okay, so I have not read this, right? All right, we have a resolution in front of us, moved by Councillor Nishikawa, seconded by Councillor Roberts. Be it resolved that bylaw 2022-192 to amend comprehensive zoning bylaw 2014-14, Aberbuck, roll number 2-9-087, be read a first and second time. And it's only a second time on the recommendation of committee that we withhold third. Anybody with any comments? Anybody with any questions? All in favor? Thank you very much. That carried. Okay. Yeah, I'm not going to read third reading. Okay, we are going to take a 5-minute recess till 10 after on that clock, just to get some clearer direction on what we do with this third reading. We'll be back in 5. And David Pink, could you join us here if you wouldn't mind, please, Mr. Director Pink? Okay, ladies and gentlemen, we'll get back to this. Counselors, please. Dinner's going to be here at 8, so okay, just so that we are clear, Averbach is now complete. Averbach is complete. Thank you very much for your patience. We have withheld third reading, and I believe there's some conditions to be fulfilled. You're aware of what they are, but we've approved it through 2 readings. So thank you for sticking around with us. We've got a couple of more issues in open forum before we go into close. Oh, no, we're going right into closed. Is that next? I'm sorry. Okay, thank you. I think you're right. I think we're done. Averbach was the last one. Yeah. Okay, so we are going to go into closed next. Council, if I could get your attention, please. Councilor Nishikawa. We are going to go into closed session. So I got a resolution to read somewhere, do I? Yeah. Good. Yeah, but we haven't moved into closed yet. Oh, I'm sorry. Mr. Soya, you're going to make noise or something. Sir, go ahead.
Thank you, Your Worship. I just before council goes into closed session, I just wanted to ask the clerk if just to confirm that all the Baker resolutions. And Mr. Pink may already have figured this out, so I'll let him speak to it.
Mr. Pink.
Thank you, Sam, for noticing. Yes, we have identified that a resolution was unfortunately missed. I'll prepare quickly those and deliver those to the clerk, and hopefully we can consider that matter again after we emerge from closed session.
Thank you both. Appreciate it. All right, I'm going to read a resolution. Moved by Councillor Edwards, seconded by Councillor Nishikawa. Be it resolved that councillor in closed session convene at 5:11. For E, litigation or potential litigation, including matters before administrative tribunals, litigation matter update, OLT appeal, B, E. E, litigation